Ladies and gentlemen, as Director of Institute of Justice, I am honored to open today's conference entitled EU Succession Regulation, a Decade in Application. This year marks the 10th anniversary of the entry into force of this regulation of the 17th of August 2015. The date brought about a real Copernican revolution in the international succession proceedings. After many years of failed attempts to create uniform regulation in this area, the European Union has for the first time created a legal instrument that not only covers the mutual recognition and enforcement of judgments in succession matters, but also introduces for the first time on such a scale uniform regulation of national jurisdiction and applicable law in succession matters. In addition, it has created a new pan-European identity document in the form of European Certificate of Succession. This was undoubtedly an unprecedented event on an international scale. Therefore, after 10 years of applying of succession regulation, it is necessary to evaluate and to establish case law. In my opinion, it is wonderful for several reasons that this conference can take place here at the Institute of Justice in Warsaw. Firstly, as a scientific and research unit supervised by the Minister of Justice, the Institute is the only center in Poland that conducts ongoing research into judicial practice based on a comprehensive analysis of court files. Every year, we examine several thousand such court files in civil, criminal, and family cases. This year, the Institute is conducting research on, among other things, the practice of applying the succession regulation by Polish courts, and we will present the preliminary results of this research at today's conference. At the same time, I am honored to remind you that this year the Institute of Justice is celebrating its 35th anniversary. Today's conference, I think, is a perfect culmination of this anniversary. Secondly, it should be recalled that the succession regulation was largely prepared during the first historic Polish presidency of the Council of the European Union. Judge Agata Srokowska, representative of the Ministry of Justice, who is present here today, was an active participant in this work. For this reason, the succession regulation and its application are of particular interest to Polish legal scholars. Thirdly, the European Commission's report on the application of the succession regulation should have been published this year. However, as we know, this did not happen. This means that the task of assessing the effects of the application of the succession regulation falls to national research centers throughout the European Union. One such center is certainly the Institute of Justice in Warsaw. Today's conference is attended by distinguished representatives of academia and practitioners of civil law, civil procedural law, and conflict of laws from the European Union. I would like to thank you all for coming to Warsaw and taking on this difficult task. The idea behind the conference is to present various issues covered by the scope of the succession regulation in several panels. We will start with a panel discussion on the achievements and future of the succession regulation. I think that 10 years is a good time to think about the future. Next, we will discuss the scope of the regulation, national jurisdiction and applicable law, and finally, we will talk about the recognition and enforcement of judgments in succession matters and the European Certificate of Succession. In each panel, except for the discussion panel, a key report and commentary will be presented. I hope that we will be also able to hold a discussion. I believe that today's conference will help us to develop directions for desirable changes to the succession regulation and to identify emerging problems in its application. I wish you a fruitful conference. Thank you very much.
This is the time to start the first panel. Thank you very much to all our distinguished panelists. The first speaker is Professor Andrea Bonomi from the University of Lausanne. He's a great expert in private international law and in comparative law. The second expert is Professor Maciej Dabgaro-Zachariasiewicz. He's an expert in private international law and renowned prominent expert in international commercial arbitration and experienced arbitrator as well. The third panelist is Dr. Marcin Margoński. He is a public notary in Poland, and many cases concerning the regulation on succession law resolved by the Court of Justice of the European Union started at his desk. For example, Kubicka case, WB, OKR, OP, BNP Paribas Fortis Bank. These cases started at desk of Mr. Maciej Margoński. The last but not the least panelist is the Honorable Judge, Ms. Srokowska. And she is experienced in dealing with preparation of the succession regulation. So she will give us insights from the process of preparing the draft of the regulation, which is subject to our conference. Each of the panelists has 15 minutes, and I would be grateful if you could keep to the time schedule. So, Mr. Andrea Bonomi, the floor is yours.
Thank you very much, dear colleague. Thank you very much, Professor Rylski, also for the very kind invitation. I'm very happy to be here in Warsaw. It's the first time. It was the opportunity not only to participate in this very interesting event, but also to discover this very nice and beautiful city. Thank you very much to all of you for the hospitality. I have this honor, but also this burden to be the first speaker. And in these general introductions to the subject, of course, it's not very easy to choose the approach. One can remain very general or try to be very specific, but in 10-15 minutes, it's not possible to develop a lot of very specific issues. I decided to try to go a middle ground. I will make some very general remarks and then try to address some more concrete and specific issue. In particular, I will try to make some remarks about the notion and the application of this notion of habitual residence, about party autonomy in different aspects in the regulation, with the regulation, and if I have time, the relation between the European system and third countries. General remarks, well, as it was already remembered, the regulation has now 10 years of application. I think we can say in general that the story for the moment is a success story. I know that this is the name of a study that is coordinated by our colleague Anna Wisocka. I think it's a success story in the sense that the regulation has been received and applied in general correctly by the authorities of the different member states. There have been a certain number of questions for preliminary rulings by the Court of Justice, around 30 requests, an important number of them coming and stemming from Poland, as it was remembered. There were a certain number of rulings, of course, of the Court of Justice of the European Union. These rulings as usual and as always, bring sometimes very important clarifications. Sometimes they might have surprise on certain results. I'm thinking, of course, on the Mankopf decision, which I think it's probably was probably the most surprising from the perspective of literature, of doctrine around Europe. But in general, I think the case law of the Court of Justice reflects what was expected by commentators of the regulation. Apart from that, there is an increasing and important number of court decisions. We are now beginning to discover this court decision in the Yearbook of Private International Law, which I have the privilege of editing together with Ilaria Pratelli. We published the last volume last year, and in the current volume that is has just been put online. It's accessible online if you want to look at it. A certain number of reports, of national reports. Last year we had 15 reports, one also concerning Poland, and this year we have other 7 reports from different member states about the application, the national application of the regulation. And I know, of course, that other studies are ongoing in this area. Once again, the study of Anna Wysoczka, and then certainly one of the institute, if I understand correctly, and there are certainly many others that will be will go more in detail on these issues. So there are several court decisions. Of course, the number of these court decisions is very different from one country to the other. Certain countries, of course, have a lot of decisions. I'm thinking about Germany or Austria, but also Croatia or Slovenia. So it does not necessarily depend on the size of the country. Of course, in Germany we know that there are many cases, also because the courts are immediately confronted with this issue, with the Amtsgerichte that are in charge for the Erbscheine and so on. In other countries, there are much less decisions. In Italy, there are very few for the moment. So it depends from the country. But I think this one of the reasons is, I think there are particularly 2 reasons. One is certainly the accessibility of decision in the different systems. So it's very interesting that this institute has access to if I understand correctly, to all the files of decision rendered in Poland, but it's not the case in other member states. And on the other hand, of course, the area of succession is an area where typically the succession is very often regulated without going to court. Notary are at the forefront, and in many cases you don't have a dispute. There are many non-contentious cases, and so the regulation is certainly applied in much more situations than it appears from this court's decision. But in any case, this court decision, as far as I could see, show that the national courts have received the regulation in a very positive way. They apply the regulation correctly. Of course, there are some cases where one may wonder if another solution might have been more appropriate, but in general, the application of the regulation is quite accurate by the national courts. In some cases, perhaps courts might have might have made a more broad use of the possibility of seizing the Court of Justice that could give the opportunity to the court to clarify certain important issues, but it depends on the national tradition of the different countries. In certain countries, it's not too common to address the Court of Justice for first instance cases or so on. So these were a little bit the general remarks. Well, of course, general remarks also imply a look to the future. As it was remembered, the Commission will have to present its report on the application of the regulation, and of course there will be works that have already started in Brussels concerning with Congress in the first part of the year, concerning the possible review or modification of the regulation. There are certainly certain areas where it's important, I think, to think about possible changes. I don't think the regulation needs a complete modification on important aspects, but there are certainly certain points where some changes can be useful. In other areas, I think it will be important to see how the case law evolves, and certain points which are still not completely clear will probably be clarified by the jurisprudence. Another possible way in the future, I think, could be, and it's valid for the succession regulation, but also more generally for private international law in Europe. It would be good perhaps if the European Union could take inspiration by what the Hague Conference is doing since many years by establishing and publishing reports, practical reports, and also a guide of good practices about the application of the regulation. I think that could be a very interesting development, because certain question can be clarified to a certain extent in the text, certain question can be clarified in the recital, but I mean, it's very important also to give some more details with the practical guide. Well, time is flying, so I will try to say some words about some specific issues. As I mentioned, I wanted to address the question of habitual residence because it's crucial, of course, for the application of the regulation, both for jurisdiction and for the applicable law. It was also an important question how it would be received in the area of succession, because it was something very new for the majority of the member states, including Poland, where the traditional approach was based on nationality. But of course, habitual residence is not new in general, because it is already applied in many other areas of European private international law, and before that in many Hague conventions. The application, of course, you know that the habitual residence is not defined. There is no definition of the notion in the regulation, but there are these recitals 23 and 24 that are something particular. It's the only regulation where you have some concrete guidance on the application of the notion of the habitual residence. And the Court of Justice has been seized sometimes in relation with the habitual residence. There are a couple of decisions. The most important one is the case EE, where the Court of Justice insisted a lot, I think, of course, rightly, on the idea of unicity of habitual residence, which is valid in general in all the areas, I think, across all the areas, but it's particularly important in the area of succession because it is very closely related, of course, to the idea, to the principle of unity of the succession, which is very strong in the regulation, and the Court of Justice, as you all know, has very much insisted on this principle of unity within the succession, in the regulation of the succession and the succession regulation. But the Court of Justice did not really provide a definition of habitual residence in that case, nor in other cases. I don't think it's a real problem, because we have a lot of decisions of the Court of Justice defining habitual residence in other areas of private international law, in particular in the area of divorce, of maintenance, so areas that concern family law in particular under the regulation Brussels I. Of course, also all the decisions concerning children, but of course, decisions concerning children are perhaps not so directly relevant for succession. But the decision about divorce in particular, I think, are certainly relevant, and I would really plead for an attempt of having, as far as possible, a unified notion of habitual residence across these regulations. I know that, of course, the Court of Justice always insists on the idea that each regulation should be interpreted according to its own purposes and its own structure, but I think the notion of habitual residence calls for a unified interpretation for many reasons, but in particular because of the notion itself of habitual residence. Habitual residence is a center of life of a person, and I think it would be quite surprising for the citizens of the European Union to know that they have the center of their life in one country for the purpose of divorce, of matrimonial property regulation or maintenance, and in another countries for the purpose of succession. Of course, there might be exceptional cases where this is appropriate, but in general, I think we have to thrive as far as possible for a unified interpretation. There are a lot of national court decisions that apply the notion, and I think what is certainly a very good thing is that courts have tried really to take into account the instructions of the regulation itself, the indications that are included in recital 23 and 24 that are very often referred to in many court decisions across many countries. The courts seems to have incorporated the idea, interiorized the idea that habitual residence should be determined based on a factual approach, on a holistic examination of all the circumstances of the case, and they really try to do a very thorough approach of all the different circumstances and to put them in balance. We have many decisions that have refused, they have clearly rejected the purely formalistic approach based on residence permits or other documents. Of course, these documents can also be indications, can be important, but they are not decisive in the determination of the center of life of a person if the factual element point in another direction. Another element which is important, I think, is that it emerges already an idea that certain criteria, certain indications are more important than others, and there are many courts that have, I think, correctly interpreted recital 24, considering that the reference to the location of the assets or to the nationality can be important, but only in residual cases as a subsidiary criteria and not as the main criteria. So I think in that direction there are good signs. I don't think it will be necessary when the regulation is revised to introduce a definition of habitual residence. There are sometimes we hear calls for definition, in particular from the notaries, I would say. Of course, I understand the request for more certainty, but I don't think that the definition will bring more certainty necessarily. What is important is probably that there will be some more cases and perhaps a guide to good practices and so on. And this will help to create a hierarchization, of course, also of the criteria, and will certainly help in the future. Very briefly to the other subjects. Party autonomy, we know the importance of the choice of law within the regulation. The choice of law has also been received very openly and very friendly by courts, not only by the notary, who always called for the introduction of party autonomy, but also by the courts. Even in cases where there was no express choice, I think it's important that there were many courts, at least in certain countries, that have applied the notion of tacit choice quite openly. Of course, there remains a lot of uncertainty in these areas. What are the criteria that could be used to determine a tacit choice? And there is a certain number of uncertainty also between the relation of between tacit choice and fictitious choice under Article 83.4. I think there, perhaps, there should be some clarification, because this Article 83.4 is a very special provision, and if the European authority could provide some more clarity about that, I think it would be a good thing, even if the Court of Justice already provided some indication about it. With respect to party autonomy, I think it should be considered to go further, in particular with respect to choice of court. I think that one of the problems of the choice of law under the regulation is that it obliges courts and notaries, etc., to apply a foreign law. This would be avoided if it would be possible for the deceased himself to make an informed choice of the competent court, as it's possible for the moment only in one country, as far as I know, Switzerland. Switzerland has an experience in that, and I think it's a good experience. I think that might help as an instrument of planification, but also to create this, reinforce this principle of unity of jurisdiction and applicable law. So I think in that area there can be some improvement. Very telegraphically on the last point, relation with third countries. I think this is an area where an effort should be made, because while living in a third country like Switzerland, even if I have a double nationality, I realize that there are some problems. This is an area which was a little bit neglected, not only the succession regulation, but in general in European private international law. I think there are two possible improvements that should be considered. I'm not very optimistic about the first one, nor about the second one. The first one is, I think Article 10 should be, to a certain extent, reconsidered. It is a constant source of concurrent jurisdiction between the Court of the Member States and the Court of the Third States, a problem which is not solved by Lispendens rules neither, so Lispendens rules could also help in that respect. So I think that there should be a reflection on how the jurisdiction of the Member State relates and not conflicts with the jurisdiction of the third countries. states. And the second area where I think reflection is important, but Anatol will speak, Anatol and the other member of the second panel, I think, will certainly speak about that, is, and of course in Poland you are very well aware of that after the decision in the OP case, and because of the many treaties you have with third countries, the question of the relation with third countries where there is a bilateral treaty, and there are a lot of these treaties in certain countries, of course not in others, so not everybody is conscious about the importance of the problem, but I think that there should be there an effort by the Commission, in my opinion, to try to develop alternatives and to propose perhaps some sort of model which can be discussed with third states. I think there are a lot of third countries that would be happy to join the system of the succession regulation. Switzerland was one of those countries, but we renounced, we proceeded unilaterally because there was no perspective of having an agreement. But I think if there were a possibility of concluding a convention with third countries, it would be very, very, very useful and very appreciated. Thank you. I'm sorry that I passed my time, but it was not.
Thank you very much, Professor Bonomi. Now the second panelist will have a floor. Professor Maciej Zachariasiewicz from Koźmiński University from Warsaw. Professor Zachariasiewicz originates from the Silesian School of Private International Law, established and developed by Professor Maximilian Pazdan. So I think he will develop some thoughts of Professor Bonomi and add something interesting and original on, in particular, habitual residence. Thank you very much.
Yes, thank you. Does it work?
Yes.
Yes. Okay. It works. Okay. Thanks. Thank you. Thank you, Bogusław. Thank you to the organizers, Piotr. Given that I'm really a poor cousin of the succession law, I am honored to be able to speak among such distinguished experts. I do assume that my invitation has something to do that the organizers have borrowed the title of our today's panel from the article that we've published a couple of years ago with Professor Pazdan. And so I make an implication that my role today is to share some of the findings that we did presented in that article. So in that I will make a selection of some of the points, and I do want to pick up on what Professor Bonomi has talked about, so the concept of habitual residence. Now, of course, we know that, I don't know, am I supposed to be green? Okay. Yeah, so of course we know it's a core concept and that we need to make an overall assessment of the circumstances of the life of the deceased during the years preceding his death to decide where the habitual residence is. And we know also from the EE case mentioned by Professor Bonomi that it's all the circumstances that should matter. Now the question that I want to put forward is the following. Should it be accepted that the deceased had multiple places of habitual residence? Now, consider an example of a business person or a truly cosmopolitan academic who genuinely lives in more than one state, spending periods of years in a different states. Now, in the EE case, the court answered this question in the negative. The court did not, I think, however, face the true dilemma because it was rather clear on the facts of the case that the habitual residence of the deceased was in Germany. So it wasn't really a truly difficult case to decide, I think, in the terms of habitual residence at least. Now, let me be clear what I mean here. Of course, under the regulation, and Professor Bonomi has mentioned that, there's the principle of unity, so it eventually has to be only one state which ceases jurisdiction and the only one legis successionis. However, if the deceased was equally connected with more than one state, then the question is whether we should weight all the circumstances to decide where the habitual place of residence is, a single place of residence, or should we accept the reality of multiple residences and consider some additional criterion to determine the legis successionis. That additional criterion could be nationality, as may be suggested under the recital 24, the last sentence. But that will only work if the deceased had a single nationality, unlike Professor Bonomi, I understand. only if that coincides with the place of habitual residence. Now, the suggestion we made, however, was that what should be decisive is the activating place of habitual residence. That activating place of habitual residence would be located where the deceased lived at the time he passed away. So it is where he or she died during the period of his or her stay in one of the countries where he or she had habitual residence. That would effectively mean that the analysis proceeds in 2 steps. So first we determine the habitual residence, and if under the totality of circumstances there's more than one, then the second step would be to consider the activating place. So this, where was the place of death of that person. And it is submitted that in this way we can achieve more predictability, and it's going to be more readily able. It was going to be more easy to identify the competent court and the applicable law for the interested parties. To be sure, that suggestion, I don't think it requires any legislative changes. It only requires fine-tuning the concept of habitual residence in practice. And that could have potentially further consequences, to which I want to move now. The first will be, should I do something here? Yeah. The first is the question of the escape clause under Article 21, paragraph 2. And I think the escape clause should be entirely abrogated. I think it's really redundant. Now, if the habitual residence is determined on the basis of the totality of circumstances of the life of the deceased, as we just said, then there's really no room for applying the law of the state with which the deceased was manifestly more closely connected, as required by Article 21, paragraph 2. Now, as a comparative note, we can observe that under Rome 1 regulation, the escape clause applies if the contract is manifestly more closely connected with a different law than the pointed by the habitual residence, than the one pointed by the habitual residence. Here, under Article 21 of the succession regulation, the Article 21 purports to operate when it's the deceased who is manifestly more closely connected with the succession matter. And this, one can ask, is there anything that could tip the scales in favor of the closest connection? So given that, I think it makes more sense, in my view, to acknowledge the fact that a person deceased had multiple habitual residences, and then to use this additional criterion to make a final choice for the just one, of course, law applicable to the succession and the jurisdiction in succession matters. Now, second, and somehow related, is the question of the choice of law. That choice under Article 22 is limited to the law of the nationality of the deceased. What we proposed is that the testator should also be free to choose the law of his or her habitual residence. So that would have certain benefits. First, it would preclude the operation of the renvoi provided in Article 34, so the testator could preclude the renvoi. Second, it would preclude the operation of the escape clause under Article 21, paragraph 2. That is, of course, if the escape clause remains, as is the case for now. And finally, if we accept the reality of multiple places of habitual residence, that would mean that the choice could include any of those places of the habitual residence. Of course, that is so long as that these habitual residences, they are really genuine centers of life of a testator. So that, I think, would allow more predictability for prudent testators who would choose to benefit from the party autonomy. Of course, there are risks, but we still have to remember that the habitual residence as a criterion is a relatively strong and stable connecting factor. And in any event, individual cases of abuse, we could use mechanisms such as fraude à la loi, or maybe even public policy exception in some circumstances. So the suggestion here is that the Article 22 could be broadened in its scope. I'm looking at the time. I still have some minutes left. Now, a different topic that I want to pick up on is Article 30. Article 30 concerns special rules restricting or affecting succession. And Article 30 gives voice to the law where certain categories of assets are located, such as immovable property, enterprises, or other categories of assets. These are not limited. They can be different categories of assets. These rules might be applied if, for economic, family, or social considerations, they impose restrictions or they affect the succession in respect of those assets. And furthermore, they apply only if they are applicable irrespective of the law applicable to the succession. The examples include rules such as special rules imposing restrictions on acquiring immovable property by foreign nationals, such as I understand under Swiss law, the Lex Friedrich, right? Or that is called. And of course in Poland we do have the similar law. Or restrictions on acquiring farms, agricultural farms, or preserving or restricting the restrictions regarding the culture, heritage, and collections of historical value. I think there is little doubt that Article 30 speaks of rules which not only serve economic, family, or social considerations, but also have a value of safeguarding a wider public interest. They intervene against legis successionis if they are applicable irrespective of the law applicable to succession. Thus, in reality, Article 30 considers the category that we know under the name of the overriding mandatory rules. It thus seems problematic to me that Article 30 breaks with that traditional terminology of private international law and creates a concept of special rules. It is submitted that Article 30 should contain an express reference to the term overriding mandatory provisions to clearly associate with the concept long known in private international law. To say that the rules apply for economic, family, or social considerations seems a little bit broad in succession law context, since succession law is all about family or social considerations. So that risks a too broad understanding of those provisions. So I think that there should be some alignment with the term overriding mandatory rules, or even definitions such as under Article 9, paragraph 1 of the Rome I regulation. And the other problem with that is that Article 30 is limited to special rules of the place of location of assets. Obviously, the rules imposing restrictions with respect to certain categories of assets are certainly most important in reality of succession law, but one might ask, what about other mandatory rules? So those not coming from the law of the location of the assets. Such as, for example, rules restricting heirship of certain categories of persons, such as employees of nursing homes, which are known in some of the countries. Article 30 and the regulation are silent here, and so it is submitted that Article 30 should make clear that even though the focus is on the rules relating to assets, but that it does not restrict the application of the overriding mandatory provisions of the forum, or possibly also third state, other than those relating to special categories of assets, although obviously any intervention should remain exceptional. And with that, I think I will pause and give room for others to criticize my view. Thank you very much.
Thank you very much, especially for the provocative thesis on abrogation of Article 21, paragraph 2. Now the time is for Dr. Marcin Margoński. As I mentioned, many cases coming from Poland on the EU regulation on succession originate in his desk. So everything starts in Krapkowice and ends up in the Court of Justice of the European Union as regards Polish context of the EU regulation on succession. So Dr. Margoński, the floor is yours.
Thank you. Ladies and gentlemen, I see some beautiful minds working in the field of succession regulation here today, so Warsaw is a good place to be, and I'm thankful to the organizers for inviting me to take part. I've been assigned, I need my presentation, I've been assigned the task to include an overview and a case study focused on the application of the succession regulation by Polish courts the Institute is currently conducting. And I will present some results concerning the ECS. As we've heard from Professor Rylski, one of the tasks of the Institute is to evaluate the operational application of law, and different actors in the lawmaking process turn to the Institute as a governmental research body for data on the application of legal institutions. The Institute has the right to ask courts to send in files of any closed court case. So that's really unique. And in this particular case, it has been the Polish Law Commission that asked the Institute to evaluate how the succession regulation is being applied by Polish courts. The study includes three parts: procedural aspects by Professor Wołodkiewicz of the Institute, joined by two external experts invited to this particular project, Dr. Wysocka-Ba, working on the applicable law, and myself concerning the ECS and the related free movement of national instruments, both in court practice. Issuing authorities in Poland are both courts and notaries. So the parties may choose one of those paths. And in September 2016, we've started registering the ECSs. And up to the 17th of August 2025, this register included 209 ECSs issued by courts within the 10 years, and 1,124 issued by notaries. But including ECSs that have been issued prior to the establishment of that register, including ECSs that have not been registered, which does happen in court practice, or which have been mistakenly registered in the national part of the register, we can estimate that around 250 ECSs have been issued by Polish courts, about 1,200 issued by Polish notaries. So altogether we have about 1,500 Polish ECSs. And the case study was limited to the ECSs issued by courts, and it included 208 files. We've already had the possibility to read, see, evaluate. We also included the ECSs and national instruments from other member states in court cases, including a register of immovables. And the first interesting information is 83% of Polish ECSs have been preceded by a national Polish procedure, so and either the notarial certificate or the court order confirming the heir status in the same case, 83%. And only a very limited number of these cases are cases that actually needed to go through the national court procedure because the succession has been contested. And it was very frequent that the applicant wrote to the court that he or she is coming back for the ECS because the national instrument issued has not been accepted in other member states. So, as you see, from Polish perspective, the ECS is in many cases turned to an annex to the national procedure. And from Polish point of view, the picture is clear. Free movement of national certificates does not work. And that includes, in Poland, both the notarial certificate, qualified by the Court of Justice as a authentic document in the case WB, as well as the court order. Although the Polish court order is a strong instrument confirming the heir status with res judicata effect, and still it's not being accepted, leaving rare exceptions aside. And this statement I made finds confirmation, and we saw that in the court files, finds confirmation in the published judgments of German higher regional courts. We have judgment stating that the German Companies Register is not obliged to accept an Austrian court order confirming the acquisition of the succession property, Einantwortungsbeschluss. That's High Region Court in Bremen. A similar judgment stating the same in relation between the heir and the company, or the heir and other shareholders. An ECS is supposed to be necessary. That's High Region Court in Hamm. Then we also have the Regional Court in Düsseldorf. The German Immovable Property Register is supposed to be able to refuse registration on the basis of a Greek court succession certificate and expect an ECS instead. And please note that those cases refer to, in one case, the strongest instrument you can imagine in Europe, so the Austrian Einantwortungsbeschluss, which is not only a classical court judgment with res judicata effect, but it's also constitutive in its nature, and also well known to the German legal system. So is well known the Greek certificate, which is a reception by the Greek legal system of the German certificate, the Erbschein. So although, you have examples, although Germans exactly know what they have to do with, those instruments are still not being accepted. But going back to the ECS, when it came, everybody, and myself included, said that and wrote, also Professor Spura as Advocate General, that it's a sui generis instrument with effects foreseen by the regulation, in the regulation, neither a court decision circulating under Article 39, nor an authentic document instrument circulating under Article 59. And that's true. But at the same time, it has been an attempt to escape the real answers. And we left a space, and nature abhors a vacuum. So the first ones who filled that space we left were the banks. And that's a quote from one of the evaluated cases, a letter from a bank to an heir presenting a Polish ECS. Our legal department came to the conclusion that the presented ECS has not been released correctly, and we will not accept it. So, in the next decade, we need to face the key question: how binding is the ECS? And more importantly, who has the competence to decide on its correctness? The answer of the banks is clear. Sue us. Sue us in our jurisdiction. It's a preliminary question. Action for payment, Brussels 1Bs. Sue us. Come to Belgium, sue us. And banks are not the only institutions who believe they are entitled to judge upon the correctness of the ECS. Reading the court files, I was amazed how patient the Polish courts have been with long lists of objections on how the ECS has been, how the form has been filled out by German clerks at Immovable Register. They also feel competent to evaluate how the ECS has been issued. It's regulated in the regulation. So they believe they are entitled to check whether that has been made correctly. If you ask the heirs, and that's also my answer, the evaluation of the correctness is an exclusive jurisdiction of the issuing member state. So as long as the German clerk at the immovable register is physically able to execute the ECS, the content should be respected. That's my answer, but that's not everybody's answer. And last but not least, registro centras. Myself, I'm very critical about this judgment. The Court of Justice has done a severe harm to the effectiveness of the ECS, and Advocate General Szpuna was right in registro centras. From the Polish angle, the Germans were right. We also share the same perspective that everything means everything. It's a structural solution of the applicable succession law. And there's no difference between being bound by a foreign singular succession within the legatum per vindicationem and not being able to question them in your own register law, that's Kubicka, and being bound by the general succession. The register law should step back also in this case. But as you know, after registro centras, it's a closed case. We're now waiting for the judgment in Marvanek. But one observation from the court files, the Polish court files, relevant here. On this matter, Polish issuing authorities have never been hardliners. So we've thought it has been wrong to question the ECSs, but if the heir wanted the inherited property to be included, the issuing authorities have not excluded that in Poland, under one condition. The ECS is a motion procedure. So the issuing authority is evaluating the motion ex officio, but it's not establishing the circumstances confirmed ex officio. That's a huge difference. And in registro centras, the Court of Justice apparently thought it was releasing a judgment friendly to the heir. They thought the issuing authority would turn to the Lithuanian, Czech register and receive all necessary data on the immovable property to be listed. And that's clearly not the case. The burden is being placed with the applicant. So registro centras has been also a disservice to the heir at the end of the day. Thank you, ladies and gentlemen. I'm at your disposal for later discussion.
Thank you very much for your very practical approach and for presenting a sample of the core activity of the Institute of Justice, which is researching real case files and court files. We are not satisfied only with observing the outcomes with the judgments, but we would like to, and we do it. We research the evidences and we try to follow the way of reasoning in particular cases. Now the time is for the presentation of the Honorable Judge Agata Sokowska, and she will have a presentation on insights from the preparation works of EU succession regulation. Ms. Sokowska, the floor is yours.
Thank you very much. It's very difficult to speak after to be the last speakers and after such a distinguished speakers as we have today. But anyway, I hope I will not be too long with my speech. I will manage to introduce something new. I would like to share with you what happened before the regulation was adopted, because as you know, I had the opportunity to follow the negotiations in the Council. It was almost 3 years, so it was quite a long time for the group to discuss all the issues. And I will also share with you what lies ahead, because there is something what is already sure, that digitalization is coming. It will change some issue concerning this regulation. And we have also in the European Judicial Network, we have a succession group in which I participate, and we discuss the changes in the attachments in the forms. So there is something on the table which is coming soon too. So as you know, the project of the Commission in 2009, I think. Yeah, it was the first Swedish presidency which started the negotiation. It was a very ambitious project because, as you know, it touched not only applicable law but also jurisdiction issue, and introduced also new document, harmonized document, European Certificate of Succession. So it was really, those days, very ambitious. Our government, Polish government, position on the draft was positive. This does not mean that we did not have fears and issues that were important to Poland and Polish citizens, at least in terms of explaining them in the group in which I participated. I had honor not only of participating and at that group, but also leading this group during the Polish presidency in the Council, the first in the Polish history. And I have to say it was a fascinating time. I will also say something about what we managed to do in that regulation as Poland during the negotiation before we get the presidency, because probably you are not familiarized with the how the negotiation and the presidency is dealing in the Council. But if you want to be presidency, you have to be very objective. So you can't introduce your interest in the new drafting when you are presidency. That's why it was very important for us as a Poland to introduce our interest before we managed to have a presidency in the Council. Poland, as many member states, were afraid about the fact that new jurisdiction connection and conflict rules based on last habitual residence will deprive the family protection from the forced heirship, yes, for the reserve, share or reserve. And this was a big challenge for our group. And what we managed to do with it as a Polish negotiator, I remember this moment when we were talking with the Hungary presidency, and we were trying to introduce the recital 24, and a concept of the last habitual residence of the deceased in a new context, in the context of this regulation. What we meant tailoring this recital differently than in the family regulations. First of all, we wanted to avoid the situation where a young person, Polish citizen, leaves to work abroad to another member state. And as a young person, this person is not thinking about choosing a law for inheritance case or leaving a last will. And is not aware also that the departure to another member state changed the entire situation for the family in the event of inheritance. Even contrary what probably the person would expect. And we wanted to avoid simply this situation. And what we have now in recital 24 is exactly what I am saying. What we were thinking was to exclude from the concept of habitual residence the situation of labor migration, which was those days very big in Poland, right? And so this is the history of the recital 24. And as a presidency now, I can tell you what was our challenge in the regulation. You maybe forget about UK. This was a big player those days in the council and during the negotiations. We were trying everything during our presidency to convince them for future opt-in. And many working days we spent on tailoring some articles for them. Entire chapter for prorogation agreements was never in the proposal from the Commission before we started to talk with UK about their opt-in. It was very difficult to negotiate this chapter about prorogation agreement in the succession cases, which is really not only for Poland, but for many member states was completely different what they are having in their systems. Because it's rather very unusual to have a prorogation agreement in the succession case. But it was done before we started to lead the group as a Poland, because of the UK. And then, not only this chapter was very problematic for us because of UK, but also the entire article which concerns the administration of a state. This now very elaborated article was elaborated during our presidency. If you compare what was in the proposal of the Commission, it was much simple. But still, we have common law system in UK, and for them it was very important that the heirs won't get a estate if they are debts. If the estate have debt, for them it was more important to satisfy creditors than to transfer the estate to the heirs, which is, I can understand their system, yes, and their thinking, but they were really unconvincible to try to find a compromise. And of course, our reserve share was also very difficult for them to accept this family protection, and because of clawback. The long tradition of donation in UK is not well known for everybody, yes? So for them, the possibility that the heir can claim from the donee some money after the estate was open was unacceptable. So we, during the Polish presidency, almost finished the drafting, except of the article for administration, which was done only because of the UK. They simply asked for more time for them to convince their parliament. In the end, they didn't opt in, but we negotiated longer than we should, this regulation, and some articles, some issues are done because of the common law system. I think that, okay, we have administration system very elaborated in the Scandinavian country, and for them it was very surprised that we spent so much time on this article of administration, which is rather for Scandinavian country so used, yes? So they were lucky having UK and their system during these negotiations. I will not prolong my short speech with sharing more secrets. If you want to ask something, you are welcome. I will just remind you that we have now a new regulation. It's the regulation about the digitalization in justice, in civil and criminal cases. And the regulation is adopted. And in Article 4, we have European electronic access point, which in future will be available in the European judicial portal, a justice portal. And this European electronic access point will facilitate the citizens, heirs, to communicate with the court in a cross-border succession case. So instead of asking for European certificate of succession in the court, starting the file, in the future, the European electronic access point will be the gate for such cases. So this is the novelty. And what about the European judicial network? I mentioned in the beginning of my speech that we are working in the succession group about something. And as you know, the forms from the succession regulation, they can be changed by the Commission. They don't need a legislation file to start to change the forms. And this is what is going to happen. Because some forms, because of the digitalization, it will be more useful and more practical to make them shorter. And update, no more is using fax, for example, yes? So we are working to facilitate the forms in the same time, having in mind that we can't change the regulation. So the working group is simply focusing on making the forms more user-friendly, more simple, but still having the same kind of base, the regulation, which is now not going to be amended. Another, and the last thing what I want to share with you is my experience from the second file, which I was chairing during the second presidency in the Polish history, which was this year. It is the protection of adults file. And why I'm talking about it today is simply because I think the lesson from this negotiation discourage Commission from introducing in nearest future connection of the registers in succession cases. We had in the file of protection of adults entire chapter about connecting of the registers, and it failed. Unfortunately or fortunately, it failed. Member states were not ready to accept this connection. They claim the fragile data, and such cases are very few to invest so much money and to introduce a connection. Many ideas to discourage Commission, and it was almost all member states. Only one was in favor of the connection. So this shows that to connect succession registers in future take time. It will be definitely not soon. And yeah, that's something what I learned from the recent file, and what I learned also from the recent file, and is still in our succession regulation, is abolishment of exequatur. In the succession regulation, we wanted to be behind Brussels 1bis because it was something new. We wanted to look slowly at this freedom of exchange of documents and recognition and execution. So we thought we will not introduce abolishment of exequatur in the succession case. This was 15 years ago, yes? And now the discussion about exequatur in the protection of adult file was none. No one has any doubts that it should be already be abolished. So time shows that new approach is in the Council, and the member state also have developed more trust in the cooperation in the international cases. Thank you very much. I hope I add something different than my previous speakers because of the experience, and you deserve soon a break, right? Thank you so much.
Thank you very much, Judge Stakowska, for sharing with us your experience from the preparatory works on EU succession regulation. This is a very unique situation and a chance to ask a question to a person who was really involved and who was very deep in the process of preparation of the EU succession regulation. Before we will go for a break, we have some time to ask questions, to discuss the presentations displayed by our panelists. So if you have any questions, you can just raise your hand and you will get a microphone from Dr. Grabarczyk. But before you ask a question, please introduce yourself. Professor Sajda.
Konrad Osajda, University of Warsaw. I have a question to Judge Stakowska and maybe some comment, because I remember that at the time when there were works on the regulation, I was invited by Latvian government to consult on this rule regarding habitual residence as determining the lex successionis. And in Latvia, there was strong discussion that is not very happy solution for countries like Poland, Latvia, and other countries, where very many people at that time particularly moved to the UK. Because then, in case of death, English law, English courts, English lawyers and their prices would apply to the succession. So there was a strong feeling that it's something that is not a good solution and should not be supported. Finally, we have it, but I wonder if the same discussion you had during the process of working on the regulation, what arguments were proposed, and maybe from other countries, did you hear about similar remarks? Thank you.
Thank you very much for this question. Of course, we as I said, the proposal provided a new departure from what we knew, the jurisdiction and conflict of law rules based on the location of property and citizenship, yes? So it was a big challenge, and it was not that we all were happy with it, but it was not possible to change this direction. It was not possible. We are in the civil law. We have to remember this was a different situation when you negotiate family law, when you expect that all members agree. Otherwise, there would be not a regulation. It might be enhanced cooperation, as we know from other files, but let's leave it for now. So, of course, we discussed it, but I think it was really very, at the beginning, decided that we can't win with simply changing the introduced new one connecting factor and one conflict of law rule, because the big advertisement from the Commission was one court, one law, one estate. And this was something so catchy that to change this idea that we won't create one conflict of rule, one estate, it was impossible. So we were discussing definition. We were discussing family protection. So in the result, we have this, what we managed as Poland to negotiate, we have this recital 24, yes, just to avoid this situation. But the experience those days was from other files that habitual residence is a new Europe. Yeah? We don't go anymore to the citizenship. Europe wanted to integrate all citizens. That's why, to achieve it, it was done by introducing different connecting factor than was in many member state national legal systems. So it was a kind of new wind. Thank you.
Oh, professor from France, yes. Please introduce yourself and then ask a question.
Yes, thank you. My name is Louis Perrot-Saucim. I'm from Paris Dauphine University in Paris. I want to go back to the question of the different numbers of cases in different jurisdictions in Europe. Because in France, for instance, there's been a few cases that haven't been transferred to the European Court of Justice because the Cour de Cassation, the higher court in France, decided not to transfer the case. So I was wondering whether there was this filter existed in other jurisdictions what was the main policy about courts transferring cases to the European Court of Justice? Are there filters in other countries or not? I don't know. It's a general question to all the members of the panel, or because I think it may have a real consequence on the numbers of cases in different jurisdictions.
So maybe we should start from Dr. Margoński, from Judge Sokowska, and then.
What kind of filters you mean?
The court can say that the issue is not serious enough to be transferred to the European Court of Justice. And
So no, absolutely, it's a freedom of asking the
so
question.
we've
We
got
don't
a
have,
filter.
at least I'm not aware about any kind of filters in Poland. You know, every court is free. It's a freedom of court to start the dialogue with the European Court of Justice. It's a European Court of Justice to filter if this, but not we receive the question at the stage that every member state receives in the same moment. So as a Poland, even if the question was lodged by a Polish court, we know it from the European Court of Justice, not before. So we decide if we participate in the preliminary ruling procedure after we receive the question, and we have certain time, like everyone in Europe, to decide, to analyze and decide. But we are not communicated with the court who asked the question. No.
Yes, my experience on two layers, where the cases you see that come to Luxembourg, my cases, it's the pick of an iceberg. So on the way, for many reasons, it doesn't come to a preliminary question. And in Poland, it's sometimes a challenge to convince the judge to make the preliminary statement. So if the court doesn't want to do it, they just release a judgment, which may be better, not better, may be wise, not wise, but often it doesn't solve the systematic problem. So also the best judgment you can have, it's not a systematic answer. It's just an answer for the case. So that was one experience, and the other one was my experience at the German Supreme Court. I had two cases concerning the qualification of German Erbschein as a judgment. And in both cases, the German Supreme Court refused to file a preliminary question using the clear doctrine. So it was supposed to be clear, and it's my very subjective statement. They've released very questionable statements that are not, I just not, as an academic, I don't accept them on the succession regulation, presenting them as act clear, which was obviously not the case. So that's the second filter.
Thank you. Yes. Professor Zachariasiewicz will answer.
Just the one, I think just a general answer to that. It's either a court sees that as an opportunity to ask something at the European Court and maybe solve the systematic problem or just answer the question, or maybe it sees it as a risk that the European Court is going to say something stupid that I don't like, such as House of Lords asking questions, can I issue anti-suit injunctions? And they are very surprised to say that the European Court says no, right? So something, the decision of the court ultimately, I guess. And maybe that's, I don't know, the French cases, the Cour de Cassation, they just knew that they know better, and that's it, I think. But it's just one comment, if I can make just one comment to something that, just to put bandages of hearts of our European colleagues. Not everyone in Poland was against habitual residence as a connecting factor. And maybe now also from Poland we see it was quite a wise decision, because we can apply Polish law to all the Ukrainians that come flow to Poland. So, you know, that does have merits at this stage of history, I guess, if we look at that from this perspective. Of course, and I'm not diminishing all the arguments that you said about the European values of that concept.
Sorry, that's why I said the regulation, the statement in general was positive. The Polish statement from the government was positive, although there was a habitual residence in the proposal, right? So, which means that we accepted from the beginning. The only thing was that we were trying to find if this is necessary, if it is necessary, what we can do to protect the family. That's why we have, for example, the limited will to there is a connection to the nationality, yes?
And now this is the time for answer of Bonomi.
Always on that question. Yeah. I think everything has been said, but the only field I think is la théorie de l'acte clair. But of course, this depends on the attitude in general, on the philosophy of the national courts. I mean, in Italy, the tradition, there is a certain tendency to ask questions to the Court of Justice. Even lower courts do that, even if they're not obliged to. In France, even the Cour de Cassation, which is in principle has a duty to raise questions, unless the question is clear, has a certain reluctance sometimes to do that. It's a matter of appreciation in the specific case.
Thank you very much. We have two more questions. One from Professor. Yeah.
Well, thank you, Jens Kleinschmidt from Trier University. Thank you for a very rich panel, but I will limit myself to two questions. The first one to Judge Strokowska concerning the connection of registers. I think that's a very fascinating idea, and I think also closer cooperation by authorities involved in succession proceedings is really key. But there are obstacles. First, it's not always courts that are involved, so the notarial system has to be included in some way as well. And also, and that's my question, would connection of registers also imply the creation of registers? Because so far, for example, we lack registers in countries. There's no ECS register in other jurisdictions, so that was very interesting to see how it works in Poland. So would the proposal also include the creation of registers? That's my question. And the other question, if I just may add that, is concerning this two-step analysis concerning the habitual residence in complex cases where, did I understand that correctly, that you were proposing to have multiple habitual residences for the purpose of jurisdiction and then narrow it down? No, so that was, and then, but then what do you do if the deceased died in a country which was not among the circle of habitual residences? Thank you.
Judge Stokowska.
Okay, so I can share my experience from as regards how member states react and what Commission propose in the protection of adults, because this shows in which direction Commission could go with a succession. So you asked if the country would be obliged to create a register. So what was proposed in the protection of adults was exactly to create a register, but it was not only about the connection of one register. It was about connection of at least two registers, as far as I remember, even three, but it was about oblige member state to create a register for court decision, which concerns protection of adults for measures. So, for example, we were the country in which we don't have a court decision in the protection of adults register, but we were only, I think, 2 or 3 countries without this kind of register. But anyway, this was one obligation. But as regards the authentic documents for representation of the adults, the proposal was saying that if the member state has the register for authentic instruments, which are tailored for protection, for representation in this file, in this field, protection of adults, then you have to connect. You have to make possible to exchange with other member states this register, but you are not obliged to create. So as regards the court decision, so I can imagine the same pattern could be introduced in this file, but as I said, it failed. The entire chapter failed. Even the voluntary connection and voluntary establishment of the register failed in the council. So that's why I am so pessimistic to see in nearest future the proposal from the Commission which concern the connection of the, or obligation for establish the register in succession cases.
Thank you very much. And now there's time for answer of Professor Zachariasiewicz.
So, just to make clear, of course, the place of death is not a connecting factor itself, but I agree there is this problem. So, what I would say is that if you can make the distinction between periods of life, say you have a person who lives in 3 months in Warsaw, then 3 months in Paris, then 3 months in Warsaw, then 3 months in Paris, then you would say when that during the when did he die? During which period? So if that person was in Paris and then went for skiing to Switzerland and died there, then it would be French habitual resident that would be activating, that would be decisive, because that was the time of death. But I do agree it doesn't solve all the problems, because what if that person would flew from Warsaw to ski in Switzerland and then was supposed to go back to his Paris habitual residence and died during his stay in Switzerland? Then I do agree that we have a gap here. So I agree maybe not all the problems are solved by my proposal. Thank you.
And now Professor Bonomi will have a short comment.
I have a comment on the proposals of Professor Zachariasiewicz. But first of all, I tend to agree on Article 21(2). I don't think it really brings a lot this escape clause. There are really very few cases that might be considered as relevant for that purpose. But we can also live with that. I mean, it's not often applied. It's not a problem. And but. I wouldn't have any objection in principle to cancel it. I also agree that it might be interesting to have the possibility of choosing the law of the habitual residence. I always wrote that. I don't know whether the situation is already sufficiently mature for that openings to the choice. But with respect to this proposal concerning habitual residence, I don't agree. I don't agree with you, because in that way I think you would give too much weight to an element that is completely fortuitous, completely casual, the moment of the death, and I don't think that it's really relevant. I prefer a solution as suggested in Article 24, where in cases where it's really so difficult to determine an habitual residence, you go back to the place of the location of the assets or the nationality. I think those criteria have more weight, and it's more significant if you take them than the moment of and the place of death in reality. I have also a small question, if I can, to Mr. Mragowski concerning this case. I don't know the case, the German case. I don't remember the German case concerning Einanwortung. The German case that refused the recognition or the inscription, if I understand correctly, of the property in the German register based on Einanwortung. My question is, what was the reason for refusing this? Because Einanwortung, as you mentioned correctly, is a decision with res judicata effect. So it must be recognized under the regulation. So if the German court refused to recognize it, it was a mistake by the German court. But perhaps the reason was that the document was considered insufficient to provide all the elements for the registration in the Grundbuch. But this is also a problem that arises with the ECC, of course. So what is the
I will
reason?
pass on the question to the future panelists, but I will answer it myself as well. It is a systematic mistake in Germany. So in Germany, they don't accept national certificates at all. They don't accept them. How it's done? The free movement is limited to other judgments, and they say the ECS is the instrument, use the ECS. They work with the definition of a judgment, that's very often narrowing down the definition. Okay. So at the end of the day, me as a notary practicing in Upper Silesia, tons of Polish-German cases, we never send the heir with a national certificate to Poland, also when it's the Polish court decision. They always use the ECS. And sometimes the Austrians accept it, the Austrian Social Security, but those are exceptions. It doesn't work. They don't accept it. And so for justification, we have German colleagues who can, I know it's not your views, you would have to give the views of other people, but you can present them maybe better than myself.
Thank you very much. This is the time for the last question from Jacopo Rei.
Thank you very much, Jacopo Rei, University of Milan, and thank you for the panel and the thought-provoking presentation. I have a question for Professor Zakaraziewicz. Sorry for if I mispronounced the surname. I totally support the idea of getting rid of the exception clause in Article 21, if it is written, if it's still written in the same way as it is today, and I can imagine that we might slightly change as per Regulation Rome 1, just telling if the succession has a more close connection with another country. Because that changed the factual circumstance that we may wait in order to have a proper escape clause. We can make it very exceptional, borrowing from Article 15 of the Swiss International Law Act that says saying that if the law determined by the connecting factor habitual residence is not so close and there is a more close law, we apply this other clause. This would be a very real escape clause. I understand now paragraph 2 of Article 21, yes, has very few rooms. And I have another, thanks to your presentation, I totally agree that overriding mandatory provisions are quite a ghost in the succession regulation, because we have Article 30, but then we have Article 26, and the law applicable to the validity of disposition of I'm sorry if I step in the section on applicable law, I'm really sorry. On the law applicable to the validity of disposition of property upon death, of wills and testament, and in that is that law that will cover, especially from an Italian private law perspective, the more case of overriding mandatory provisions that are the case in which a person cannot dispose towards two certain figures, the doctor, the nurse, and the notary that help with the will. These were before the regulation consider overriding mandatory provision. So maybe we can foresee a new recital that takes into account the category of overriding mandatory provision, just saying that they are not neglected, they are dispersed in these two rules. Thank you very much.
Thank you very much, and before you start answering, please remember that only 1 minute left from this panel, and then we should start coffee break, which is a kind of...
I do intend my my answers to be very brief. Particularly with these comments were so incisive that I don't think I have very much to say. But with respect to the closest connection to the succession case, now, would that be, I'm not sure. I mean, the problem is, I think that the succession cases could be different, right? So would we then consider the closest connection to succession case, which can be a different type of a succession case at hand, right? Is it the, I don't know, the clawback issue, the forced heirship, or is it a question just of confirming the succession in general? Or would that be, so if we would be looking for the closest connection to the succession in general, but wouldn't that be the EE case from the Court of Justice, where they tried to argue that the nationality and the location of assets then this overrides the habitual residence of the deceased. But that's sort of, I think that's a very risky idea, and wouldn't we overturn the habitual residence in general? So I don't know. I would be skeptical here, but that's just the sort of initial thought. On the other point, I don't know. It's just, I think my comment is that I would agree that I think there should be clear room for applying overriding mandatory provisions other than those mentioned in Article 30. So that could include the rules that you've mentioned, and maybe just the specification in recital would be enough here. But given that under Rome 1 and Rome 2 we do have a specific provision on overriding mandatory rules, so then there's a question, why don't we have something similar in the succession regulation that would generally open the floor to, exceptionally of course, but to overriding mandatory provisions? I don't have any intelligent answer to Article 26. I have to think about that. Thank you.
Thank you very much. I would like to thank again on behalf of the Institute of Justice to all our distinguished panelists, to the Judge Agata Strokowska, to Dr. Maciej Margoński, to Professor Maciej Zachariasiewicz and Professor Andrea Bonomi. Thank you very much for the answers from the members of the audience. Now the first session is closed, and I would like to invite you to the coffee break. We are meeting again at 11:30. Thank you very much.
Ladies and gentlemen, we are ready to embark on the second part of our journey during this conference, the second panel that will be focused on scope and interplay with other instruments and international conventions. And I have privilege to chair this panel with two fantastic panelists. First will speak Professor Anatol Dutta from Ludwig Maximilian Universität Munich. He specializes in private international law and comparative law. He graduated at Hamburg University and Oxford University. He also cooperates with Cambridge Family Law Center, and he published widely. I'm sure that everyone here knows the very provocative title of his, in my view, most famous book, Warum Erbrecht? And our second panelist is Professor Louis Perrault-Saussin from l'Université Paris-Dauphine, who specializes in private international law and the law of arbitration, as well as real estate law. And he works at the Paris-Dauphine University. He published widely, and he's a member and director of graduate program at this university, and member of many scientific committees and other scientific bodies. The first will be the presentation by Professor Dutta, and then commentary, and then I hope we will have interesting discussion So I won't take any more seconds, and I will pass the floor to Professor Dutta.
Yeah, Konrad, thank you very much for the introduction. Of course, it's a pleasure to be at this wonderful city and in this really impressive institute. I didn't know that such an institute exists in this country, but I think it's a really very useful institution, especially the close contact to practice, which is often missing when it comes to policy making, think tanks, which are often more academic and less practical. I'm honored also to open the first discussion on one of the different parts of the regulation. The topic is the scope of the regulation and the interplay with other instruments, but especially the interplay with international conventions. Of course, mainly conventions by the member states with third states, which were already mentioned in the first panel, which cause, I think, the biggest problems in that field. The topic is rather heterogeneous and very, very broad. It's more or less like I don't know, a sum of many small problems and different issues. So also I have to apologize for my PowerPoint presentation, which is really more or less a mess because I try to list most of the problems regarding the scope. So I do not have a big theory or a coherent presentation, but nevertheless I would like a little bit to structure the discussion and to structure the problems when we think about the scope of the regulation. I would like first to look at the scope ratione personae, so the spatial or personal scope of the regulation. There's not much in the regulation on that. Then I will, of course, look to the substantive scope, so the scope ratione materiae of the regulation. And I would briefly also would like to touch on the temporal scope, the scope ratione temporis, because we have, at least in Germany, lots of really difficult cases in that area of the regulation. Then I will look to the interplay with the international conventions, as already mentioned. I will not look specifically to the interplay with other EU instruments. I will touch on those issues, of course, when we talk about the material substantive scope of the regulation. Of course, here is the place where we have to delineate the succession regulation with the other EU regulations in the field of private international law. But first, a brief look on the scope of the regulation ratione personae, or I mean the personal or spatial scope of the regulation. If we look to the text of the regulation, there is nothing on, no general rules on the personal scope of the regulation. So there are no explicit provision on the scope, but also there is no uniform scope for all parts of the regulation. Rather, we have only implicit and differentiated rules when it comes to the scope ratione personae. In particular, there is no kind of no general unwritten restriction that the case needs to have a connection to the European Union or to the member states. Of course, we have no explicit case law on that regarding the succession regulation, but of course we have case law on Brussels I, Owusu, 2005, old case, 20 years old now, but also on Brussels 2A, I think it was still 2A, what was it, I think UD versus XB, I'm very bad with the acronyms, UD versus XB case from 2018, where the court stressed again that the European jurisdictional provisions, they do not need to have, they apply even if there is no strong connection to the European Union. The case concerned a child which was situated, I think, in Bangladesh when the case had to be decided. So there are no general rules, but we have to look to all the different parts separately of the regulation. And if we look to those parts, we will discover quickly that the rules on international jurisdiction, that they apply if the deceased has had his last habitual residence in the European Union. If parts of the estate are in the European Union, this can be basis for jurisdiction under Article 10. And even if there is somehow a connection to European Union, if you think of Article 11, forum necessitatis, so very loose strings to a member state suffice to bring the jurisdictional rules into application. No restrictions, we have found no restriction when it comes to the applicable law. I mean, those provisions apply universally. They even apply if there are only strong connections to a third state. Article 20 clarifies this universal application. Also, the rules on the acceptance, recognition, and enforcement of judgments, but also court settlements or authentic instruments, also there is no restriction when it comes to the scope ratione personae. The only precondition is that the judgment, the court settlement, or the authentic instrument comes from one of the other member states. If it comes from a third state, of course, the national provisions of the member states apply. And the same is true for the European Certificate of Succession, because, of course, it can only be issued if there is jurisdiction in the European Union, Article 64 of the regulation. So the same restrictions as to jurisdiction also apply to the European Certificate of Succession. Yeah, are there any problems when thinking about the scope ratione personae? I don't think so. I think we can forget the whole slide. There's simply no problem. You simply apply the rules. You simply apply the rules, and it's only of academic interest, yeah, that the regulation indirectly also defines its spatial scope, but for day-to-day work, I think no problem at all. Yeah, much more complex, as you all know, are the rules on the material substantive scope of the regulation. There are lots of problems because, of course, succession law has many connections, as you all know, to other areas of law, and we always have to decide when we have a case which has also a relationship to another another area of law. We have to decide which parts of that area are part of the applicable succession law, or whether the courts competent for the succession matter are also competent to deal with those neighboring issues. Yeah, I think the rules of the regulation are quite straightforward in that regard. As a starting point, we have Article 111 of the succession regulation, which clarifies that the regulation is applicable to the succession of the estates of deceased persons. We have a very broad and not very helpful definition in Article 31A, where I think nobody learns anything about succession law when looking to this very broad and it's only says succession is successions. But at least we have some definition there. Of course, also the other definitions in Article 3 might help when it comes to the substantive scope of the regulation. For example, the definition in 3.1b on succession agreements. If, of course, something is a succession agreement, then probably the succession regulation will apply to applicable law, but also to jurisdiction regarding this agreement. Yeah, the regulation supports the public a little bit in defining the substantive scope by a negative list and a positive list. We have the negative list in Article 1.2 and a positive list, as you know, in Article 23.2, although, of course, Article 23.2, I mean, from a merely like a formal perspective, only applies, formalistic aspect, perspective only applies, of course, to the applicable law. But of course, if something is covered by the applicable law, probably it's also within the scope of the succession regulation. Yeah, if we take together those two lists, there is a number of really like neuralgic issues, critical points. I just want to address two of them because we have case law of the European Court of Justice regarding those two issues. One is the distinction scope of the succession regulation to matrimonial property law, and the other concerns property law. Of course, matrimonial property law is closely linked to succession law in many regards. I think here in most systems, the delineation is quite easy. I mean, matrimonial property law defines the consequences of the death for the dissolution of the matrimonial property regime, especially if there are common goods, how they have to be shared between the surviving spouse and the heirs of the predeceased spouse. But of course, we have the very problematic provision in the German civil code, which is, I think, now in the meantime has become world famous. The Article 1370, para 1, which has a different approach and allows a lump sum or has a lump sum approach, increases the statutory share of the surviving spouse by a quarter in order to avoid a compensation under matrimonial property law. And you all know that rather quickly, I think it was one of the first decisions of the Court of Justice in Luxembourg, the court came to the conclusion that this provision has to be characterized as an issue of succession law and not matrimonial property law. So in Germany, we are now in the funny situation that we have to apply a provision of matrimonial property law, which is in the systematic part in family law, in the fourth book of the civil code. We apply it if succession law, if German law is the applicable succession law. And of course, there are really difficult follow-up questions because this provision is part of the German statutory default matrimonial property regime. The question is, does it only apply if the couples are married in that regime? And the answer is, of course, no. This is a question of substitution. So even if they are subject to a foreign matrimonial property regime, it can qualify as a Zugewinngemeinschaft, the German term for the German default regime. And this is a question of comparative law. We have to compare the foreign regime to the German regime, whether it has the same concepts. But if we do so, we will discover that the German solution is rather, I think, is wrong, and it's unique. And so in practice, the provision now only applies if German law is also the applicable matrimonial property regime. I mean, but I think I'm the only one. I think that if Austrian law is also the matrimonial property regime, I would also apply 1371 and Liechtensteinian law maybe, and maybe Greek law, but not any other system. Yeah, about this distinction between succession law, matrimonial, and property law, I do not have to say much. You all know the Kubicka decision. I mean, the spiritus rector is sitting in front of me. You all know that succession law has close links to property law as well when it comes to the allocation process. So how the assets of the deceased are allocated to the beneficiaries, however they are called. And also regarding the allocation results, succession law can also change the property regimes, applicable property regimes, and I mean, it's quite clear from the wording of the regulation that all those effects are part of the succession regulation, and this in the end was confirmed then also regarding the legatum per vindicationem according to Polish law. Was confirmed by the Court of Justice of the European Union. I think the decision was no surprise at all. It was only a surprise for German notaries, which tried to keep the case law from the pre-regulation to the regulation. Yeah, there are many other. I can't go into details of the other problems. There are many other really complex problems, delineation between succession law and neighboring areas of law. Company law, for example, still not solved. Which parts of succession law, which parts of company law can be part of succession law? If company law has, like, and I think in Polish law you have also special succession rules for certain company shares. Is this succession law or is this company law, the applicable company law? It's really complex questions. So far, no case law at all. Only literature is discussing this problem. Also, the same applies to intellectual property rights. Most intellectual property legislation, there are special succession rules for certain intellectual property rights, and the question is how to delineate them. Yeah, just a brief word on the temporal scope of the European succession regulation. I mean, the principle is quite easy. The regulation applies to successions of persons who died on or after the magic date, the 17th of August 2015. So this is rather straightforward, I think no surprise. But then we have this special provisions regarding choices of law and regarding the admissibility and substantive validity of dispositions of property upon death, which were set up before the application date of the European succession regulation. And at least, I don't know what the situation is in other member states, but in Germany we have really vast case law only on those two provisions, which I think has mainly to do with the fact that we have in Germany binding dispositions upon death, succession agreements, and mutual wills. And often the question arises whether, for example, a German-French couple, a German-Italian couple, they entered into a joint will before the application of the succession regulation. So from a German perspective, for the French spouse or the Italian spouse, there would not be any binding effect of that. It would be even void. The whole agreement would have been void from a pre-regulation perspective. And now the question arises: what happens if the person dies after the date? And as the binding effects of the disposition is that we do not have a special rule on that, because especially Article 83.3 only applies to the admissibility and substantive validity, but not to the binding effects. Yeah? So the binding effects is probably subject, at least to German case law, subject to para 1. So we have really a change of regime on the 17th of August. So a disposition can turn binding, valid and binding, after the regulation has started to apply. And then the question is, has this retrospective effects on, for example, if there was a second will even before the application date? Some courts say yes, others say no. So many complex questions. So, but I think it's a German speciality because of the binding dispositions upon death, which are really popular in Germany and really used in Germany a lot. Yeah, briefly, also, fiction of choice of law. That's also. I mean, I don't know what's the situation in other jurisdictions. Also, we have lots of case law on 83.4 on the fiction of a choice of law. If you, it's not clear what you have to do, but if you testate under the law of your nationality, what does this mean? Does this mean implicit choice of law? Yeah. What are the preconditions for such a fiction of a choice of law? There's really lots of case law on that, because, of course, it happens quite often. Yeah. Many people, they testated before the date. Yeah. Briefly, interplay with international conventions. I mean, the rules, if you read them as such, they are not very difficult. Article 75 in particular. As you all know, we have a precedence of existing treaties, so it applies only to existing treaties. Of course, the member states cannot conclude new treaties anymore, according to the, the AETR doctrine, I think, of the Court of Justice of the European Union. So they lost competence to conclude new treaties, but of course there needs to be a rule dealing with the old treaties. The approach is based also on Article 351 of the Treaty on the Functioning of the European Union, that the application of those old treaties has to be preserved, because the European Union cannot force the member states to violate their public international law duties. So, for example, the application of the Hague Testamentary Reform Convention is preserved, but also the bilateral treaties of the member states with third states. Of course, this does not apply to existing conventions between the member states, mainly conventions concerning recognition and enforcement of decisions in succession matters. They are, of course, they apply. They are ousted by they are superseded by the succession regulation. Yeah, you all know that, especially the bilateral treaties with third states, that they are really a problem and cause a lot of trouble. Germany has only 3 of those treaties, but you know that many member states have more than 3 treaties. Especially, I think also Poland has a number of treaties. Most of you know that I was part of a project. We tried to find some of those treaties. We didn't look to Poland, which was a mistake, but often, yeah, I mean, you know, funding is limited, and sometimes you make mistakes in your life. Yeah, and this was clearly a mistake. It was clearly a mistake, but it was pre the Morgonski case, the Morgonski cases on the Ukrainian treaty, and it was prior to, I think, the Ukrainian the war. Yeah, so we had no idea that Poland. But we had no idea at all when we started with the project. We had, for example, no idea that France has difficulties to find a treaty at all, whereas other Czech Republic, I think, is the champion of treaties. They have, I think, most treaties in the European Union. So we tried to collect them in this book, and you all know that they cause really trouble because they destroy the decisional harmony within the European Union. I mean, only the simple case of a Turkish national having assets in Warsaw, but last habitual residence in Germany, Polish courts would decide the case differently from the German courts. And the problem, of course, is additionally that, for example, we could have 2 under the WB doctrine. We have contradictory certificates of succession in such a case within the European Union, which is simply, I think, not acceptable. Yeah, that the treaties are important is also recognized by the Court of Justice, but you all know that case. I think this case also highlights the problems of those international treaties, especially the interpretation of those treaties. I've always difficulties to understand the second answer of the Court of Justice, but I think the problem is the double negation. If you read it carefully, the court says that, of course, if there is a treaty, a choice of law can be excluded by the treaty. And the question is, of course, how you interpret the treaty, whether the silence of the treaty is a no when it comes to choice of law, or whether it allows a choice of law. Yeah, so to close my presentation just briefly, I think that the provisions on the scope of the regulation are as good as they can be. It's really difficult to draft provisions on the scope of such an instrument. Maybe one could have spent more time on the intertemporal scope, but that's always a problem, that you do those provisions in the end when everything is done and everybody wants to go home, and nobody has time to think about the problems which might arise in the future. I think most of the problems which we are faced now, at least in Germany, they were not anticipated by the Council. I think it was in the Council mainly the Article 83 of the regulation. Of course, the old treaty problem, that's really a problem, but I mean, Andrea already proposed a solution. I think that should be really a topic of the, I mean, it's very political also. I mean, I can't imagine that the German government in the current situation, for example, would cancel the treaty with Turkey, because then we have no diplomatic relations with Turkey anymore, which would be not good. And I think a partial cancellation of a treaty is also difficult. So it can't be the member states can't do it. It has to be, the impulse has to come from Brussels, and Brussels should offer those close friends, third states, as Andrea proposed, something in advance in order to get rid of those old treaties from the last, sometimes even from the 19th century, partly. Yeah, I think that was all I wanted to say. Thank you very much.
Thank you very much, Professor Dutta, for a very interesting overview of the problems. And as quite frequently during scientific conferences, and I think it's perfect result, we have less doubts at the beginning and more doubts at the end. So the mission completed. And now we will look at the same issue from French perspective. Professor Louis Perrault-Saussin, the floor is yours.
Thank you very much. I want to start by thanking the organizing team for inviting me to this very timely and strategic conference on the EU regulation on succession. So as you guessed, my approach on the matter will be slightly different from Professor Dutta's presentation, as I have been asked to talk about the scope of application, adopting a French perspective. So I will start with three introductory remarks. My first remark no, anyway, there was an introduction, doesn't matter. So three remarks. Our conference aims to examine a decade of application of the EU regulation, and it seems to me that one of the main points here is to see how the European Court of Justice has shaped the interpretation of the scope of the regulation. My second remark, I will talk exclusively about the material scope of the EU regulation, mainly because this is where we've got the main numbers of cases. I will not discuss the temporal and territorial scope of the application. We might talk about it later on. And my third remark is that adopting a French perspective, it can be slightly challenging, and for two reasons. The first reason is that there's only one decision of the European Court of Justice dealing with a French situation, the Vincent Pierre-Oberlé case. You all know about it. The second reason is that if we have a look at the French decisions on the European succession, there are 9 decisions from the French Supreme Court, the Cour de Cassation. There are about 30 decisions from the Cour d'appel, the lower courts, and none of them deal with the scope of the regulation. Therefore, I will not be able to give you an insight on the practice of the EU regulation on that specific matter. Instead, I will focus on the following question. I will try to see to what extent is the European Court of Justice interpretation on the subject matter of the material scope of the EU regulation on succession satisfactory or adequate from a French point of view. And I will try to, I will start with what seems adequate, and I will follow by addressing the questions that appears inadequate, and I will start with my first part. So to understand the situation from a French point of view, one needs to go back to 2015. At that time, I guess it must have been the same in many jurisdictions, French lawyers were concerned about the many changes that the regulation would entail. And I think the interesting point here is that the European Court of Justice dealt with those concerns, and mainly in two respects. First, in making sure that there will be some continuity between the French former solutions and the EU regulation. That is the first point I want to make. And secondly, by maybe most importantly, mitigating the effects of the most radical changes set out in Article 1 of the EU regulation. So on my first point, continuity, I think we've got many examples of the continuity between the former rules under French law and the EU regulation. Know that, for example, then when the Matsukova case in 2015 states that the approval of an agreement for the sharing out of an estate concluded by the guardian on behalf of minor children is to fall outside the EU regulation. This is perfectly in line with French privileged understanding of the matter, and the same can be said about the distinction, the boundaries between succession on the one hand and matters concerning recording in a register of right in rem on the other hand. The combination of the broad interpretation of the material scope of the EU regulation and Article 69.5 on the effect of the European Certificate of Succession could have led the European Court to give a very narrow interpretation of the questions falling within the category of questions relating to recording a register of right in rem. But instead, we can see that the European Court tries to avoid any encroachment between the law governing succession upon the question related to register rights in rem. I'm referring here to the Kubiska case, obviously, but I'm also referring to the Registri Centras case, which says more or less the same thing on that subject matter. From a French point of view, this approach of the problem ensure continuity of the former French solution, and it's also quite satisfactory from a French point of view, as the provision of the French Civil Code that requires the intervention of a French notary for the registration of property rights in the French land registry, will not be affected by the application of the succession regulation on that matter. Now, if I move to the second point, the Court of Justice mitigating the effect of the most radical changes, I think there's a very important point to make here on the following point. In 2015, the main concern of French lawyers was related to the change of the conflict of law rule on succession, namely the transition from the traditional rule distinguishing between movable and immovable property to the unity rule set out in Article 21 and 22 of the regulation. Obviously, this change in the conflict of law rule has a direct impact on the scope of the regulation, since you all know that Article 1.2 specifies that the nature of right in rem is excluded from the scope of the regulation. I think it is important to understand the shift, how important the shift was from a French perspective, because before 2015, French lawyers, French practitioners hardly ever had to consider the boundaries between right in rem on the one hand and succession matters on the other hand. One of the obvious reasons is that the immovable property was subject to the lexitus rule in both cases. So the problem arose only in relation with movable property, and we didn't really have any significant case on that matter. However, and I'm going to go back to the Kubiska case, this very concern was dispelled by the Court of Justice in the Kubiska case. You know that the case provides clarification, explanation of the interpretation that needs to be given to Article 1 and Article 31 of the regulation. So obviously I will not go into the details of the Kubiska case, but I will just make 3 observations on this case. Firstly, the case clarifies the meaning of the wording nature of the right in rem. There's a few lines in the case giving you the signification, telling you that classification of property and rights, determination of the prerogative of the holder of such rights, existence and number of rights in rem are the different important points that defines the category. Secondly, there's the fluidity between the 2 categories, right in rem on the one hand, succession on the other hand, is entirely based on the use of the technique of adaptation of right in rem provided by Article 31 of the regulation. Well, you all know that it is a very complex technique to use. It is very uncertain in the results when it is used. But however, I think it's important to insist on the fact that from a French point of view, this is a technique that has been used specifically in inheritance matters and precisely to define the legal category of succession. We've got few case law examples where the adaptation has been used precisely to shape the succession category. Thirdly, if the applicable law to succession in the Kubiska case would have been French law rather than Polish law, the outcome of the dispute would probably have been very similar, as French and Polish law both have the same category of legacy vindication. So this was my last one. I will move to the second part and then try to point out the unsatisfactory points or questions from a French point of view. In my opinion, the main source of concern here can be summarized as follows. The interpretation guideline provided by the Court of Justice to define the boundaries of the EU regulation on succession are not strong enough to provide legal certainty and predictability. I will start very briefly by presenting those guidelines, and I will try and pick up a few examples of the difficulties of those guidelines under French law. So the first guideline, there are mainly three guidelines. The first guideline is unity of the law applicable to succession. In several cases of the European Court of Justice, we can read, for instance, for reason of legal certainty and in order to avoid the fragmentation of the succession, that law, the law of succession, must govern the succession as a whole. The second guideline is the effectiveness of the European Certificate of Succession. Then again, we've got several cases where this specific guideline is used to define the category of succession. In the Mankov case, for instance, it is said that the achievements of the objectives of the European Certificate of Succession would be impeded considerably in a situation such as that at issue in the main proceedings if it did not include full information relating to the surviving spouse's right regarding the estate. The third guideline is strict interpretation of exceptions. In the UM case, it's the best example I found. In the UM case dated 2021, the Court of Justice stated that the assets transferred otherwise than by succession are excluded from its scope, and this exclusion must be interpreted strictly. So those are the three guidelines, main guidelines that you find in shaping the scope, the material scope of the European Court of Justice. What I want to do now is show you, or try to show you, that those three guidelines creates somehow uncertainty under French law, and I will give you two examples. My first example, I will start with in the Mankov case, the Court of Justice used mainly guidelines 1 and 2 and decide that the Article 1371 of the German BGB must be classified as succession. However, from a French perspective, the reasoning of the court cannot created some problem because it cannot be transposed to another institution that is also at the borderline of matrimonial property and succession. And this institution is what we call les avantages matrimoniaux. So in French law, avantage matrimonial results from various contractual arrangements within the matrimonial community, derogating from the principle of equality between spouses. And one of the examples that could be given is the clause providing for the full allocation of the community property to the surviving spouse. In principle, under French private international law, the characterization of avantages matrimoniaux is matrimonial, except where the protection of the children from a previous marriage is at stake, then the succession characterization prevails. The question here is whether the ruling in Mankov changes or has an influence on the characterization of this avantage matrimoniaux. On that point, there are under French law different positions. Some consider that the case, the Mankov case, has a direct effect on the traditional characterization as matrimonial, as Mankov has a very broad interpretation of the scope of the EU regulation on succession, but others think that it has no effect on the characterization and that the matrimonial characterization should be still the one to be used. My second example is even a better illustration of the uncertainty created by those three guidelines. As you know, in the UM case of 2021, dealing with the distinction between agreement as to succession on the one hand, included in the succession regulation, and donation excluded from the regulation. And in this case, the court used both guidelines number 2 and 3, but none of the two guidelines were strong enough to decide whether the issue at stake should be considered as contractual on one hand or succession on the other hand. The matter at stake here was an Austrian contract under which a person provides for the future transfer on death of ownership of property. And the question was whether it was falling within or outside the scope of the regulation. And the court had to add a third element, a temporal criterion, namely that the contract needs to take effect at the death of the deceased to fall within the scope of the regulation. This reasoning of the Court of Justice in this very case leads to uncertainty under French law regarding the characterization of an institution that is widely used under French law, and that what we call the donation partage. Donation partage under French law is a mixed act. It is an inheritance contract on the one hand. It allows someone to organize its succession in advance, but formally it is a donation, and it creates effect at the date of the act. So on the one hand, it's inside the scope of the succession, but on the other hand, some of the elements are outside the succession regulation. Here again, if you have a look at the UM case, and the criteria that I've mentioned, it is very difficult to decide whether the donation partage is outside the scope of the regulation or inside. There are different opinions on that subject matter, and definitely those guidelines are not strong enough, once again, to decide whether the succession characterization should prevail. I think I have finished. I have concluded my intervention, and I will now happy to answer any questions you may have. Thank you very much.
Thank you very much, Professor, for, again, a very interesting presentation, clearly showing that everything that is located on the borders, that is unclear where it belongs, creates the most difficult questions, problems, and also opens up discussion. Just going back to your last point, in Poland, we have also a very interesting discussion about donations mortis causa versus donations post-mortem. And we sometimes say that if you think of donation mortis causa, it's effective at the very moment of death, so it's closer to succession. But when you say that it's donation post-mortem, it's effective inter vivos. And only some effects happen at the moment of death. So we share these problems as well. And now it's great to open discussion, so you are welcome to ask questions or share comments. We have a few more minutes until the end of the panel, so everyone is invited to take part in discussion. Please, over there, Dr. Borysiak.
I would have one question to Professor Perrault about the last topic that you already mentioned, donation partage because you mentioned that there are different opinions, different commentaries in France about this topic, about this possibility, how to solve this problem. And what is your personal opinion on that field?
Thank you. Thank you. Please go ahead.
Thank you very much. From a French perspective, before the case 2020-21, most scholars would have told you that the donation partage were within the scope of the regulation, because it was a, I don't know how you say it in English, but in French, a pacte sur succession future, and because of that, and for that very reason, it had to be considered as a successual matter. But then the difference here is that you've got this temporal aspect, this questions on when does the contract enters into force, creates effect. So obviously you can have a discussion about what does it mean, creates effect, at what moment precisely does the donation partage takes effect? Is it at the moment when you sign the contract? Is it at the moment of the death of the deceased, well, the cusus? My opinion would be that because of this interpretation of the European Court of Justice, we have to consider that the donation partage falls outside the scope of the regulation because it takes mainly effect at the time of the act. But then the question is, if you don't apply the succession regulation, so what should you be doing? And which should be the rules that you would apply to donation partage?
Excellent, thank you. Do we have any other questions? Professor, please go ahead.
Thank you. I would like to ask one question or add one item to your list of uncertainties, which already was mentioned on the first slide among the adequacies of, where the French law regards the succession regulation as adequate, and that is the requirements for entering land into the register, the attestation notariée. So the question would be, I think this also falls somewhere between the scope and outside the scope of the regulation. If you can really require an additional certificate or an additional document in addition to the, for example, the European Certificate of Succession for entering land into the land register. So I'm just curious to know from the inside French perspective, what is the current practice, or what would happen if I came with an ECS to France and request ownership in a French plot of land?
Thank you for your question. So we are talking about the way that the Article 69.5 is interpreted by French lawyers. I mean, the question is mainly a question for the application of the regulation by notaries in France. Obviously, we have the European Court of Justice cases stating that, well, if you don't have the complete information on the subject matter in the certificate, then you cannot use it for the land registration. My feeling is that on that subject matter, the main trend would be a very conservative approach of the problem, saying that we've got an article in the civil code that tells you that you need to go, you need a French notary to register your land in the land registry in France. And I think because of the way that the European Court of Justice has interpreted this very question, and plus because of this text, the position of the notaries would be to say that you cannot really use the certificate for the benefit of the land registration, and then you need a national certificate to have the complete pieces of information.
Thank you, Professor Bonomi.
Thank you very much. I have a question for Anatole. You evoked also, as I also did, this question of Article 83, paragraph 4, which is a quite unusual provision in the sense that if you establish an act in conformity with the national law is deemed to be applicable to the whole of the succession. What is your opinion about this inconformity? How should that be determined? Is it more substantial, substantive aspects, or even simply formal aspect, the fact of having established the notary wills, for instance, would that be sufficient? What is your feeling?
Yeah, it's a very, very difficult question. I mean, it cannot be like it's. I mean, the question is what is subjectively necessary in the intentions of the testator when choosing or not choosing, when establishing a certain will under the law. Available under the law of his nationality. I mean, it cannot be like a hidden choice of law, so an implicit choice of law, because otherwise there would be no need of para 4. This would be covered already by para 2 of the regulation. So it has to be something in between. I think that at least the testator needs the intention to testate, at least regarding the substantive validity of the will according to a certain law. I don't think it suffices that the testator only wants to use a certain form of a will, but that at least there's an intention of the testator to testate substantively under a certain law. But I mean, this is like a photo finish, yeah, where this can also be an implicit choice of law. So it's really difficult, and courts. I mean, there are some like Court of Appeal decisions, German Court of Appeal decisions. They really struggle in applying that provision. Yeah, it's really also. I mean, there are also additional questions. What happens if such a disposition is revoked later? Yeah, or there's a new disposition later? Is this also a negative choice of law then? Really. Many difficult questions, and it's practically very important because many, of course, cases of succession, of course, there have been wills before the 17th of August 2015.
Excellent. Thank you very much. As we reach the time that means it's the end of the panel, I would like to thank you very much, our fantastic panelists, even greater audience for excellent questions. And now we will make a huge move from private international law to private international procedural law and to the issue on jurisdiction. I will pass the floor to the next panelist. Thank you very much.
At the side of the table. The lady should always be in the middle. Would you like water?
Yes, sure. Ladies and gentlemen. Yes, so ladies and gentlemen, I hope we are ready to continue our great conference. After the first two panels, the scene is set definitely to go deeper and now focus on jurisdictional matters in the third panel. I have a great pleasure and honor to commence it thanks to Professor Piotr Rylski, who invited me to participate. Many thanks for that. It's really a great pleasure to be here in Warsaw in such an excellent company of scholars. This panel will feature a joint report by two excellent scholars from the University of Milano, that is Professor Lenka Walkowa and Professor Jacopo Re, who will delve into some issues that were already introduced in the previous panels, and I'm sure that they will add a lot of practical as well as theoretical insights in that regard. And after such a presentation, then Professor Rylski will add his comments from the Polish perspective as well as a general overview of these issues. From my point of view, coming back to the first panel, I think that when speaking about the success story and achievements of the regulation, we haven't mentioned the one group of parties that may be happy with that regulation. I mean students. I think that students do appreciate the concept of a unity of court, unity of jurisdiction, this attempt to coordinate jurisdiction and the applicable law issues, which at least to some degree reduces the complexities of these matters, which quite often for the beginners in the field makes them feel overwhelmed by the fact that completely different connecting factors may be decisive on these two fields, which seems and in reality are working in tandem. So without further ado, I will give the floor to our great presenters. Please, Jacob. The floor is yours.
Thank you very much, Professor. Thank you very much to the Institute of Justice in Warsaw for having invited me in this wonderful conference and the wonderful receiving we have experienced. And on a personal note, thank you very much, Bartosz, to have given our name, Lenka and my name, for this presentation conference. It's wonderful when projects of the University of Milan and University of Warsaw within the 4U+ family that connects our university can have a further development. So thank you very much. Sorry. Our presentation is divided into three parts. I will deal with the first one, the general rule on jurisdiction. So determine habitual residence. I will be very brief on that because already Professor Bonomi said the key elements, and I guess that we will dwell well during the session on applicable law. So just some remark on that. Then my colleague will speak on those jurisdictional ground that require a choice of law of a member state by the deceased, then passing to the third set of rules that are jurisdiction involving mainly third states. And so this is our presentation. First, a little warning, which is also the very first footnote of the course of Professor Bonomi in the Hague Recueil. I guess it was in 2009. We have always to remember that we are not dealing anymore with an affair of rich people when speaking about cross-border succession. So the rule has to be clear, the rule has to be easily readable also for those who have international relation, and that the liquidation and the continuation of a little patrimony might be as difficult as the one of a golden boy. That was the remarkable words of Professor Droz. We already said, and the presentation is divided into 3 parts because 3 are the sets of rules posed by the succession regulation, with each one has a different connection with a member state. The first one will deal with the habitual resident in a member state, the second one, the choice of law of a member state, and the third one, the presence of assets in a member state, plus or minus other requirements in order to establish a jurisdiction on the succession as a whole, or on a jurisdiction to rule only on assets. And then the succession regulation want to ensure justice, providing with a forum necessitatis in other situations. And of course, the last 2 sets of rule, presence of assets and forum necessitati, will call into cause also third state countries. So the general rule, very brief, the course of the member states in which the deceased has his habitual residence at the time of death shall have jurisdiction to rule on the succession as a whole. We already know we don't have a legal definition. We have 2 recitals, and thanks to the Honorable Justice, we know now how the second recital 24, has been drafted and why. So first recital 23. Recital 26 gives us the method in order to determine the deceased habitual resident that has a method that requires us to see the stability of the stay, the duration of the stay, and the intention of the stay. So we can say that we have 2 constitutive elements, duration, settled intention, and in order to ascertain the center of the life of the deceased, we have to see all the factual and relevant factual circumstances. That might be the physical presence and stay, the reason, the family and personal connection. Some weight has to be attached to working interest, property, because we're dealing with succession, estate and patrimonial assets may be movable, immovable, immaterial goods, bank account, foreign workers remittance, localization of digital assets. So everything that the deceased left has to be taken into account. But then we can also think about citizenship. Maybe we can also think about the language that those people spoke, because we will see that this will be relevant. We have just simply to pinpoint on a map all these connections, and then we have to group them. But how we group them? We ponder them. We simply group, or we weigh the contacts. Of course, we have to weigh the contacts, and sorry, no, it's not complete. You cannot see the color, and of course, there is a proportionality. The more the succession is international, the harder it is to find the habitual residence. The most complex cases are also the most challenging one. We have also a help in recital 24 in the case for the labor migrants, or when the deceased lived in several states alternatively. These are factors that we can take into account, and we can benefit also from the Court of Justice of the European Union, that not only in the Oberle case, but also in EE case has already judged and explained the functioning of the habitual resident, but we can also borrow some insight from the jurisprudence in family matters, such as the IB versus FA, the MPA case, and the Linderbauer, but also from member states' case law. And thanks, of course, to the Yearbook of Private International Law for the reports. We see now that the courts of the member states are quite well versed now in identifying the deceased habitual residence. The idea to find the center of the lives is well established. some present dealing with medical treatment, even prolonged present dealing with medical treatment, has not been taken into account in order to determine the habitual residence in the place, even for a long time, where the person lived. We have also interesting, no, sorry, there should be another, no, an interesting case where in Austria the deceased live alternative in two states, Spain and Austria. In that case, the judge counted the days, counted the reason. In Spain, the Austrian citizen lived for the most part, bought the dream house, wanted to grow old with the spouses. He came back to Austria for medical treatment for a long time. They had a flat there, so we have personal property, we have intention in both countries, but nevertheless, the Austrian court found the habitual residence in Spain. We also have some not so good practice, because we have to assess all the relevant facts. So not only the registered residence and the citizenship of the person. We have some cases from Croatia where jurisdiction was granted only on those bases, and the higher court overruled this decision, requesting the court to assess all the relevant facts. But we may also have negative conflict of jurisdiction when a court of a member state it doesn't have jurisdiction because habitual resident is in another state, and the court of that member state states we don't have jurisdiction because habitual resident is in the first country. So we have to avoid this kind of situation. We have an example with the Ljubljana Higher Court of 22 July 2020 that overruled the decision of the first court and assessed that the habitual resident is in Slovenia. These are just some example of the application, a decade of application of the regulation in order to determine habitual resident. Habitual resident is the center of the lie, assessment of all relevant circumstances, weighing of contacts, and at the end, the court has to decide where the center of the person is.
Good afternoon, everybody. I would like to thanks one more to organizers and also to Professor Vojtkovic, that was our 4U Plus visiting, so I'm very happy that we can also continue in our collaboration in this way. So my task is to speak about the party autonomy when it comes to the jurisdiction rules. So mainly the rules that we can find in Article 5, 6, 7, and 9, because they interact together and must be read together. So as the introductory word, I would like to say that all these rules are designed in order to ensure the parallelism between use and forum. So it means that the member state can apply its own rules. But first, I would like to focus on Article 5 of the succession regulation, that it was already reminded that during the adoption process, on the beginning, there was no rule on a choice of court agreement, but there was only a rule on a choice of law agreement that represented the cornerstone of the system, and only in 2011 it was inserted into the regulation in order to enable a parallelism between use and forum. I think that this objective we can read directly from recitals 27 and 28, which refers to the mechanism which enables to the member state court to apply its own rules. So what are the, in any case, we know that under Article 4 and also under Article 21, it's any case possible to reach this Gleichlau, so the parallelism between applicable law and jurisdiction. But in any case, we could hear that can be some kind also of the problems regarding the determination of habitual residence. In any case, we know that the nationality, it's more straightforward connecting factor jurisdiction ground. So what are the conditions for applications of Article 5 of the succession regulation? So the first one, that the deceased must make a valid professio juris under Article 22. it will be referred by our colleagues in another panel that it refers to the nationality of the deceased. And also through the universal application of succession regulation, it can be a law of any state, so it means that the deceased can be a national of any state. On the other hand, when it comes to jurisdictional grounds, when it comes to party autonomy under Article 5, it requires the connection with the member state. So it means that the deceased must be a national of the member state in order to proceed with the choice of court agreement under Article 5. What is also very relevant that we have to focus who makes the choice of court agreement. So in this case, the choice of law agreement must be made by the deceased. On the other hand, the choice of court agreement must be chosen by the parties concerned in favor of the member state court whose law has been chosen before by the deceased. So also during the adoption process, it was modified several times, this all parties concerned and who are the parties concerned. At the end, we have this meaning, we have this notion of parties concerned. And it was referred also during the adoption process that should be a definition provided, who are the parties concerned. But at the end, we know we don't have any definition. So it can be sometimes very problematic to identify all the parties concerned. In any case, I will refer in a while that when all parties concerned are not parties to the agreement, it's somehow also possible to heal this kind of situation through Articles 7 and 9 of the succession regulation. So under Article 5, it's possible only to make an exclusive jurisdiction agreement. So it means that the member state court who has been chosen has jurisdiction. And this is then confirmed in Article 7b. So according to my opinion, Article 7b does not say anything new, just confirms that that member state that has been chosen has jurisdiction to decide. What is more interesting is to refer to negative derogation effect, which is strengthened through Article 6b of the succession regulation, and which requires the derogated, so the non-designated court, to decline jurisdiction in case that there is a valid jurisdiction agreement, also choice of law agreement that is prerequisite of it. And what happens then? Article 7a proceeds, so continue, and says that in such a case of declination, again, the designated court shall have jurisdiction. So for me, just like if you see all these articles, all these rules, for me, they are kind of complicated to read it. I think mainly for end users. But, and also some kind of situation could arise. Now I think to the situation when, for example, the derogated, so non-designated court was seized as the only seized court in that situation, or is first seized court in case of respondents, and must assess the validity and the existence of jurisdiction agreement. So how far should go through evaluation of the validity of the jurisdiction clause? So in the doctrine, it was already on the beginning, it was referred that that court, so the non-designated court, should proceed with the full review approach. So it means should assess completely the validity of such a jurisdiction clause. And this decision as to declining of the jurisdiction and as to a decision if that jurisdiction agreement is valid or not, it then is binding on the designated court. So it can be then read again through Article 7a that I was referred before, that after that moment, the designated court cannot review anymore the correctness of this assessment of the non-designated court. So what is the advantage of this approach? Advantage for sure is that it avoids the negative conflicts of jurisdiction and the degeneratio justitiae. And I think that in any case, it's not so new, this approach, because when we are going to Gotthard case, when it comes to Brussels Convention, Brussels regime, it was stated by the ECJ that the finding on the validity of jurisdiction clause and on the declining on jurisdiction is then binding on of any other member state courts. I think that this approach was then taken also by the ECJ as to a succession regulation, even it was not referred to the jurisdiction clause, but to Article 6a that I will speak in a while. And the ECJ stated that the decision as to the declining of jurisdiction then represents a decision within a meaning of Article 3(1)g of the succession regulation, and such must be then recognized and enforced in other member states and cannot be subject of any other examination after it. So this, when it comes to this kind of problem. When it comes then to the evaluation of formal requirements, Article 5.2 provides that this agreement should be in writing, dated, and signed. I think it's nothing new because we know it from also a regulation in family matters. But it was also discussed in doctrine in this case if, for example, a unilateral declaration by the party, by all parties concerned, could be also fulfill the requirements provided in Article 5.2. According to my opinion, it's not possible, also through the case EE that I will refer in a while. And so that there should be an agreement of the parties. The other thing is that when it comes to the standard clause of electronic communication, that we know also from Brussels regime, it was also arise, it can arise some, there was some discussion regarding if digital signature is necessary, or if it's, for example, sufficient that the choice of code agreement is signed and scanned by the parties. I think that also nowadays, and we are in 2025, it's necessary also to speak about the digitalization and new digital technologies. So we can also speak about distributed ledger technologies. And nowadays exists also, for example, the small notary system that provides for a possibility of validation of documents, but it can be also coupled with all smart contracts that are written in algorithmic code. So according to my opinion, the choice of law and choice of code agreements should always remain in a natural language, but it cannot be excluded that in the future there will be also these clauses written in algorithmic code. So my question is, could it fulfill the requirements of Article 5.2? Because there is also signature through private code, so it could in theory. In any case, Article 5, we have to distinguish also through Article 7 of the succession regulation, which provides that the court whose law has been chosen shall have jurisdiction if the parties expressly accept jurisdiction. So it is different than the jurisdictional agreement provided in Article 5. And it was also discussed on the beginning what kind of formal requirements should be satisfied. If there are those in Article 5.2 or other requirements. I think that now from the ECJ case law of EE could be somehow read that it requires different standards of formal validity requirements. And when it comes to Article 7c, so the express acceptance, in such a case, it could be also another standards that should be evaluated under the procedural law of the seized court. Now, we have to also distinguish this situation through jurisdiction based on appearance, that is in Article 9 of the succession regulation, that it's different that we know from the Brussels system, or Brussels regime, of civil and commercial matters, because it somehow permits to heal that situation that I was speaking before. So we can imagine that we have a choice of code agreement, but not all the parties were party to that agreement. and that designated court has been seized. So what happens? So in such a case, it's possible so that the court that has jurisdiction under that jurisdiction agreement shall continue to exercise the jurisdiction if the parties enter the appearance without contesting jurisdiction. So it's a little bit different. The other problematic thing is that no rule on substantive validity of the jurisdiction clause, because we know that in Brussels 1 bis regulation we have the express clause on substantive validity of the jurisdictional agreement that refers to the conflict of law of a designated court. There is no rule when it comes to the succession regulation, so in the doctrine it was discussed if this approach should be followed. According to my opinion, it would be a very good idea because it provides for the uniform solution for all member state courts. And it's very important taking into the consideration that mechanism that I was also talking about, so all the communication between Article 5, 6, and 7 of succession regulation. In any case, there could be also another solution, so only refer to the formal requirements. It was on the beginning referred by the ECJ and Trasporti Castelletti, or to follow also the national approach that it depends on the classification of the effects and nature of jurisdiction clauses. Then it can lead to the application of lex fori or lex causa, so it means that there will not be any uniform solution. So I personally do not favor this approach. The last rule that I would like to discuss is the Article 6a of the succession regulation that again provides for another rule that provides for the healing the situation that it's not possible to arrive to parallelism between use and forum. So it can happen that deceased choose the law under Article 22, but there was no jurisdiction agreement. So in such a case, we do not have this parallelism. And Article 6a provides that in such a case, when the law has been chosen at the request of the party, it's possible to decline jurisdiction in favor of better placed court. And in such a case, by virtue that the parties are habitual resident in that place or the assets are located in that place. So we can see the objective again is Gleichlaw here, but it's also accompanied by another objective in this case that the jurisdiction should be closer to the succession in this case. It was also held by the ECJ in case RK. I would like only to conclude my speech just saying that, of course, all these rules, they are really complicated. When I saw all the cases regarding the rules, I found only one case that referred to Article 5. So my question is why? And my personal opinion is because it's very complex, this kind of communication between the courts through Article 5, 6, and 7. And also the other thing is that now it could be also considered maybe to broaden the party autonomy when it comes to choice of law agreement, and then it could be also accompanied by a choice of court agreement. So I will now also pass.
Last part of the presentation. Sorry, Lenka.
Yes, sure.
So what happened when habitual residence of the deceased is outside the European member state bound by the regulation, not the European Union. We also have Denmark and Ireland that are not bound by the regulation, outside a member state bound by the regulation, but there are assets in a member state. Can we have a jurisdiction that can rule on the succession as a whole? Yes, if we couple the presence of assets, we don't know how many, how much. The important is they are inside, in a member state, with either the nationality of the deceased, so assets in Poland for a Polish national that had habitual residence in the United Kingdom is sufficient. It's okay for having jurisdiction of Polish court for rule on the succession as a whole. Or failing this combination, if we have assets in a member state bound by the regulation where the deceased had his former habitual residence in that member state is sufficient to have jurisdiction if a period of not more than 5 years has elapsed since the last habitual residence changed. These rules gave some problems or required some interpretation by the Court of Justice of the European Union, because the first problem was, is there a duty for the court seized to examine of its own motion these criteria? The court was clear in that sense. Yes, there is a duty from the court seized, and it was the case VA and ZA. Is necessary in order to have the subsidiary jurisdiction that no other court of a member state has general jurisdiction. That was quite easy, but the Court of Justice answered in the positive. Of course, there should not be other court that has general jurisdiction according to Article 4. And the most recent one is the location of assets of the state in a member state should be on the time of the opening of the succession or on the time when the action is filed. And the Court of Justice recalled that the asset has to be present on the time of the opening of the succession, that any other measure taken by the heirs are not important. They do not deprive the court with jurisdiction. There might be another question is, are the heads of jurisdiction alternative or successive? Of course, from a literal point of view, we have the successive answer, and some member states, for example, the Swedish Court of Appeal, also endorse this view. But I wanted to stress out that we have a time element in letter B of paragraph 1, and this time element does not relate to the succession. It's relating from the change of habitual residence to the time the court is seized, and echoed the time element in Brussels 1 regulation, or from the conflict of law perspective, Article 8 of Rome 3 regulation. But with these other two regulations, we deal with a person that moves and leave a country and gain connection to another country, and those connections become stronger as long as they live in the new country. Here we deal with a person that dies, and I cannot fully understand why we cannot have a slight change of the rule from 5 years at the time the court is seized to the deceased has his previous habitual residence in that member state in the 5 years before the death. So we do not have a time limitation on the action. We do have, I think it might be better that we have a rule that say, we have a former habitual resident in this country, the habitual resident has been changed in more than 5 years, this country has no title to exercise jurisdiction. The habitual resident has been changed in less than 5 years, or we can choose another time, less than 4, less than 3 years. This country does have to have jurisdiction, because the nature of the rights does not decrease in time. The nature of the right that derives from a succession are those at the time of the death, and do not decrease. Of course, there is a time limitation in order to join the right. But the nature and the strength of the right with the territory of the state does not decrease with time, as when a person moves from a country to another. Going swiftly to another, sorry, I didn't show the slide with the proposed change. That's very rude on my part. Coming to the other question of only assets, no problem with this situation where no court in a member state has jurisdiction. The court of member state in which assets of the states are located shall nevertheless have jurisdiction to rule on those assets. And we have some interesting case law from the member state that I have outlined, and maybe we can share later the PowerPoint presentation in order to outline there. Last question, the forum necessitatis, I complete the rule on jurisdiction. The succession regulation has a forum necessitatis that has to be interpreted according to the case law of the Court of Justice of the European Union and the 4 elements that have been outlined. So no court of a member state should have jurisdiction. A court of a third state should be closely connected with the situation. In that third state, a proceeding cannot reasonably be brought or conducted, and there should be a sufficient connection with the member state of the court sees. And also this provision has been taken into account in the case law of the member state, in one case in order to leave the door open for proceeding in Germany for a succession that was the habitual resident of the deceased was in Thailand, and in Poland, in order not to assess forum necessitatis for a succession involving Poland and United Kingdom. Of course, United Kingdom is a third state country, but we can not say that it's impossible to have proceeding in the United Kingdom, or they are a mere inconvenience. I do not have time for Article 12, which is also relevant in dealing with estates that are in a third country. But we have a sound interpretation and application by member states. Again, there are some good examples of application. Just to say that maybe we should enlarge the discretionality of the court, because now the court can limitate the proceeding only at the request of the party. But the party might not be aware that the decision cannot be enforced in the third country, and sometimes the court might have a broader discretionality. This will lead to assess if rules of lis pendens with proceeding in third parties are to be considered, but of course I do not have time to speak about this. And I thank you very much, together with Lenko, for your attention.
Grazie mille, Jacopo and Lenka. It was really a very informative, enlightening presentation. It wasn't for sure any kind of Italian torpedo. It was rather a super fast Italian train full of knowledge and expertise in the field. So many thanks for that. I'm sure that there are many other things that we would like to discuss if you have more time. But now, without the further ado, it's time for the comments from the director of the Institute, Professor Piotr Rylski. Please.
Thank you, Professor Olaś. Thank you, reporters, for this panel, for the perfect presentation, very detailed presentation about the jurisdictional issues of the succession regulation. I know that I have no much time, taking into consideration that we've got a lunch, and I'm the last panelist before the lunch, so I should be present my commentary in the very smooth way. I try to do that. But General, your report, I think that is the proof what I would like to say at the beginning. Do you think that the succession regulation is too complex, especially in the context of the jurisdiction? Because every year when I am preparing for my classes with judges in the National School of Judiciary, I think it's a very, very difficult topic. And I know that it will be very difficult to explain judges, not students, these rules on the jurisdiction. I know also that majority of them do not apply these rules, and I will tell you why, but they do not want to do that. But it's very complex to find out about the case law, about the application and effects of this regulation. So I think that for the future of the succession regulation, maybe this is the question, should we simplify the rules of the succession regulation, especially in in the field of jurisdiction, Articles 5, forum non-convenience rule, subsidiary jurisdictions, there are so many difficult, complex, and deliberated rules which should be much more simplified, I think. So starting, I would like to tell you something about the practice, about the problems of Polish judges, about the jurisdiction issues. We know that the succession regulation is based on the very important goal. This is the Gleichlauf, and sometimes these very complex and deliberated rules are related with those aim to obtain Gleichlauf principle, but it's very difficult to fulfill in practice. Of course, we know that we've got the rule of unity of forum, which should be base of the regulation. So I would like to start with the rules concerning general jurisdiction, next couple words about the subsidiary jurisdiction, and finally about alternate jurisdiction. General jurisdiction, we know that Article 4 was an important change for the practice of Polish judges in 2015, because according to this provision, the courts of the member states in which the deceased had their habitual residence at the time of death have jurisdiction to rule on all matters relating to succession. This is changed to the Polish rules which was enforced before 2015. This rule means in practice that Polish courts have had to change their approach to hearing inheritance cases, as the starting point for any further action should be to establish, beyond any doubt, the last habitual resident of deceased. This is necessary not only to determine whenever it is located in Poland, what is quite easy, I think, for Polish judges, but also whenever it is located in any other member state of the European Union, and it's much more difficult to do that. Only then it is possible to invoke to the limited jurisdiction provided for the Article Point 2. We should to exclude the habitual residence in another member state. The issue of deceased nationality, location of estate should be examined in the second stage. But unfortunately, practice shows that this mechanism is not correct in Polish case. Two examples why. First of all, this is the problem of the bilateral agreements, because the nationality of the testator may affect the exclusion of the application of the succession regulation. So Polish courts is obliged to verify in the first way the citizenship of deceased, because you know we've got the many bilateral agreements regulating direct jurisdiction with Ukraine, with Belarus, with Russia. In the case of citizens of these countries, in accordance to Article 75 of the succession regulation, the jurisdictional basis of the aforementioned bilateral agreements take precedence, and these are based on outdated connections of nationality and location of property, movable and immovable. The European Court of Justice case law has taken quite liberal approach, thanks to Dr. Margoński, to the interpretation of Article 75 of the succession regulation. But this did not concern the issue of jurisdiction, I think, because the decision in the case C21 from the 2022 regarded the choice of law, not the jurisdictional issues. So I think it does not appear that the judgment referred, this judgment could justify a refusal to apply in Poland the provisions on national jurisdiction resulting from bilateral agreements. The second problem in practice, many questions arise how to determine the deceased habitual residence. As is well known, Poland is still a country with strong immigration to EU. We have talked about that today morning. This immigration is often temporary and involves dividing one's residence between Poland and another member states. As is well known, Recital 24 was prepared for Polish cases or similar cases like Latvian cases, etc. And in this recital, we've got the connection with citizenship and the location of a state. So this provisions of this preamble, especially recital 24, are very often invoked by the Polish courts and are applied as it would be a jurisdictional ground. The provision of the preamble encourage Polish courts to refer first to connecting factor of Polish citizenship or the location of property in Poland, not searching the last habitual place of residence. This is particularly the case when there are difficulties with determining the last place of habitual residence. They search as often as can the citizenship or location of property, and it's very easy for them because they've got the jurisdiction and the Polish law as applying here. Of course, it was not the objective of this recital, but it's done in practice. What a case with the subsidiary jurisdiction and limited jurisdiction towards, it appears that the subsidiary jurisdiction under Article 10.1 of the regulation is not a solution often used by Polish courts. This is despite the fact that the case of law, you saw this case law thanks to Jacopo concerning the obligation to applying Article 10 ex officio. Polish courts often, after finding that the deceased did not have their habitual residence in the EU and determining that they were a Polish citizen, switch to applying the Polish Code of Civil Procedure, Article 1108 of the CCP. In practice, it's difficult to find cases where Polish courts have sought grounds for assuming jurisdiction on the basis of the succession regulation. In such cases, however, Polish courts rule only on immovable property located in Poland. So they obtain the result which could be obtained thanks to application of the Article 12, for example, but they based on the Polish Code of Civil Procedure. In summary, it can be concluded that the mechanism of Article 10 of the succession regulation, which assumes the existence of subsidiary jurisdiction based on the estate in a member state, but not on the entire estate, is not very intuitive for Polish courts. It also greatly complicates succession proceedings as it requires the application of foreign substantive law, because we've got the divergence of jurisdiction and applicable law in the case of Article 10. And at the end, the most important for practice in Poland, Article 13, alternate jurisdiction. Article 13 on national jurisdiction in matters concerning the acceptance of a declaration of responsibility for succession debts is of great practical importance in the Polish legal space. This provision allows the beneficiary of an estate to make the declaration listed therein before the court of the place of habitual residence of the persons making that declaration, even if the national jurisdiction in the succession case lies with the courts of another member states. And we've got many cases because we've got the proceedings in Belgium, France, and other countries, and we've got the people interested in that proceedings living in Poland. The ratione for introducing alternative jurisdiction of Article 13 was to make life easier for beneficiaries of succession, and it's quite obvious. A declaration made before the court of the member state of the habitual residence of the person making it replaces the declaration provided for it law in the law applicable to the succession. In practice, such declarations are often made before, as I said, Polish courts. They are also made before a Polish notaries. In the latter case, there is a question as to whether a Polish notary should examine ex officio the existence of the jurisdiction under Article 13 of the regulation, even though it is not recognized as a court in the case law of the European Court of Justice. The doctrine, for example, article Professor Wojtkiewicz, has expressed the view that there is no such requirement as it does not follow from Article 13 of the regulation or from Polish law. This view is correct, but we've got different opinions about that. The second, Polish courts are often have a problem whether they should, following the example of Polish law, to inform a foreign court of a submission of such declaration. We know that we've got the recital 32, that it's not necessary, but this is the habit of many Polish courts to inform somebody about this declaration. In practice, there are also doubts as to which declaration fall under Article 13 of the regulation. In a recent judgment, in a Polish case, C57, I think, of 2024, the Court of Justice rightly pointed out that the courts of the member states in which the person evading the legal consequences of failing to submit a declaration of renunciation of succession within the time limit specified in has their habitual residence do not have jurisdiction. So we do not apply this article to such declaration. And of course, the determination of national jurisdiction under Article 13 requires establishing whenever the person making the declaration has their habitual residence in the member states of the court before they make the declaration. In practice, it's difficult because this proceedings is very simple. This is the one-party proceedings when we've got only the person who would like to depose the declaration before the court, and we should ex officio search the jurisdiction and the link with the case. To conclude, because I know that it's very, very late. First, the jurisdictional provisions of the succession regulation, apart the general rule in Article 4, are very detailed. We see that, we know that, which makes them difficult for national courts to apply. Of course, it's very fun to discuss about that in the close circle of scholars and academics. It's very fun to write some commentaries about that, but it's really difficult to apply in practice. These provisions are related to the material and territorial scope of application of the succession regulation, which makes their application in practice difficult due to the existence of bilateral international agreements. This is the Polish case too. The third, the principle of uniformity of the forum for court cases, although very important, encounters numerous problems in practice, in particular in relation to the determination of the composition of the heirs' estates. And what is, I think, also very important, the jurisdiction Article 13 of the regulation is a very useful instrument in practice, but its scope of application raises really, really important doubts. In practice, it is also difficult to determine the conditions of habitual residence of the persons making such declaration when the act itself is not particularly complicated. So I think that we should find which basis of jurisdictions are applied in practice and decide to simplify that to cover the whole problems which we've got with a different laws applying in the succession matters. So thank you, and sorry for the long presentation.
Many thanks, Piotr. So we clearly see that this unique perspective of combining and confronting theoretical approaches with the practical, down-to-earth one may lead to a question whether there is a necessary level of sophistication or perhaps over-complication which justifies the call for a certain degree of simplification. Frankly speaking, I wonder whether this perspective, this finding corresponds to the perspective of the members from different jurisdictions, but for sure this makes our discussion much broader and more complex, if I may use that word. So I know that everybody hopes that we will finish and go for lunch, but I think that such a very, very, very interesting discussions also calls for question from the floor. So please, who would like to start our discussion? Anna, yeah?
Anna Wysocka-Bar, Jagiellonian University. Not long ago, it's the question to the whole panel. Not long ago, I was organizing a seminar with practitioners concerning the application of the regulation. And when we discussed the rules on jurisdiction, it turned out that the question that caused the most vivid discussion was how to understand the notion of assets under Article 10. And the practitioners, they were giving, oh, and Anatol went out, I wanted to ask him also. The practitioners were asking, can we treat as an asset a civil law claim? And this is quite popular in Poland, claims for the restitution of the nationalized assets that were nationalized after the Second World War, and now you might fight in the court to get them restituted. And then also the question, can debts constitute assets if it is in the interest of, I don't know, the tax authority or social security institution or the bank to have the case heard in Poland?
Thank you very much. So who would like to tackle this difficult question?
Very interesting and quite complex indeed, and I guess it was for the European project that you are coordinating with also my dear friend Silvia Marino for the okay. It's assets has to be of the deceased. Of course, they might have a positive value, but also a negative value, because those are the positive for the creditors of the positive value will have to be within the creditor. We do have a regulation, I think it's recital 27 or 37 that speak about the protection also of creditors and their position within the regulation. So I can, I just considering it about and for sure claims for restitution that has to be performed in a member state link those assets, especially if are immovable, link those assets to the member state. Of course, there should be the preliminary question, is the claim valid? That they will open the door to the validity of the claim, and I'm not sure that might be also governed by the rules on jurisdiction of the succession regulation, because at the very end there should be the transfer of a immovable property or movable paintings, I don't know, other jewels, movable properties that belonged in to the deceased. For debts, why not? Why not? Because we have to protect the debtor. Though it is a part of the estate. You cannot calculate the estate without debt, at least in civil law tradition. If we apply the common law tradition that the estates are only those that remain at the end of the procedures, those are another part of. But we do not have member states that follow. Well, maybe we also that has a very complex procedural aspect, but we do not have this family, at least to my knowledge. I don't know that follow this situation. So I think, I hope I answered your question.
Piotr, do you want to add something? Okay.
May I? Yes, of course, this is an important issue, especially for Polish courts, because we are always think about the positive elements of assets when we think about dividing, for example, community or something like that. But I think that for Article 10 assets, this is the very general and very broad notion. But the problem is different, because I think that it's not it's out of the discussion that the claim for something is the element of the asset of the estate. But where is the place? Where is the location of this claim? This is a topic, because what should decide about that this claim is in Poland? Why this claim is not abroad? Where is the creditor, for example? Of course, we think about the subject of the claim, this benefit or this performance which should be fulfilled by the debtor, but I'm not sure where is the place for that asset? Like my claim to another person to pay to bring me back some thing, some immovable property or something like that. In immovable property, I think we think about this place of this immovable asset. But if it's not the immovable asset which is the subject of this claim, I'm not sure where is the place. This is the place of living of the creditor or somebody else. With the debts, I've got some doubts about that, because of course this is the element of my situation, but it's not a state of assets of the estate. It's in these words we may find that debts. I'm not sure. You know, in Poland we've got the grounded case law that we cannot share debts in the civil proceedings when we share the community, yeah? Because we cannot share that, because it's not, we cannot division between a couple different persons. So what is the debt? I'm not sure. At this moment, I would like only say that it's doubtful that we may say that debts could be the element of assets of the estate if we read the whole phrase from the Article 10. Thank you.
Thank you. Any more questions from the floor? Professor Bonomi, or yes, please.
Well, it's actually more remark than a question, fortunately, and it goes to habitual residence that was discussed in detail, and which is not only the common thread of the regulation, but also of today's conference, it seems. The first remark goes to this little quote from the French textbook on droit international privé, which referred to the travailleur migré, the immigrant worker. I think this is quite illustrative of how habitual residence also shaped our image of what is a cross-border succession. Because today, thanks to habitual residence, the immigrant work is no longer a problem, and probably not a cross-border succession. But it's rather, if we speak in Erasmus terms, not the incoming, but the outgoing person that causes the need for regulation. And the other aspect is that I think it was quite right to deal with it in the jurisdiction panel, because that is also where the problem comes up in practice. The question of habitual residence is usually raised in the context of jurisdiction, and not so much in the context of applicable law, because at that point the court or the authority dealing with the succession knows where the habitual residence is, and if we adopt the same notion as we should, and as was already said in the discussion panel in this morning, the thing is settled for applicable law. Thank you.
Extremely briefly, I completely agree that the rules of Article 5 to 7 in particular are extremely complex. Lenka has explained them very well, but they are extremely complex. This shows, I think, that it's important to have a different approach. If we really think that the convergence between the jurisdiction and applicable law is so important, and I think it is important, then why not simply presume that if there is a choice of law, then the court of the chosen law also has jurisdiction? Perhaps we can complete that with a possibility of derogation if all the heirs agree, so invert the rule. But it would be, I think, easier to have this approach. And on Article 10, the presentation, the excellent presentation of Jacopo also shows that it goes very far. This all-inclusive jurisdiction based on assets that might be one single property item or a claim even. I don't think that it comes into play. I agree with you. But I think it goes very far. It creates big problem with third countries, at least with Switzerland, which has also a similar approach based on the domicile, habitual residence of the deceased. I think it would be good to at least to limit the jurisdiction of European courts to assets situated within the European Union in those situations.
So, it looks like we are ready to conclude this great panel. I would like to thank a lot all the participants for their tremendous performance and the audience for being present, asking questions, and your great participation as well. Thank you very much.
Everybody to be seated. We are starting another session. My name is Mateusz Pilich. I'm a law professor at the University of Warsaw, and it's my honor, privilege to preside. And now we are approaching a very important matter of designation of the law applicable to questions of succession. Well, no need to say that these problems are crucial for the European states. Most of member states of the European Union survived a kind of major overturn in this respect. It was a true revolution, and well, it's now time, after some period of 10 years of the application of the regulation, to have a kind of summary regarding the application of the regulation. It was my obligation also to mention that we have a coffee table. Anytime you need a refreshment, please feel free to go and take some. Well, now Professor Jens Kleinschmidt from the University of Trier gives a presentation on the law applicable to succession.
Well, thank you very much, Mr. Chairman, for the introduction. Many thanks to the organizers and to the Institute for the invitation to this conference, this very stimulating conference, and also for the opportunity to get to know this fascinating institution here, the Institute of Justice. Dear colleagues, we're moving step by step through the regulations, so now it's the third part, it's applicable law, and I think the rules on applicable law are really at the core of the succession regulation, because they are not only relevant in judicial or probate proceedings, but they are also relevant already at the stage of estate planning. And moreover, the rules on applicable law remind us of three overarching principles that have already been mentioned, and I will not go into the details, but just to call them back to after the lunch break to our memories. First, the harmonized rules take universal applications, so they may also designate the law of a third state. Secondly, the rules implement the principle of unity of succession. So they speak in Articles 21 and 22 of the succession as a whole, which is a change for a number of legal systems that before the regulation provided for a scission of the estate. So movable and immovable property were subjected to different rules. The succession regulation, I think, facilitates the treatment of cross-border successions. And thirdly, the regulation enshrines a concurrence of jurisdiction and applicable law because the general rule on jurisdiction and on applicable law use the same connecting factor. This enables courts to apply their own law. I will divide my presentation into two parts. The first part will deal with the conflicts rules contained in the regulation, while the second part will focus on the application of these conflicts rules, and that is general questions of private international law. Before I go into the details, I would like to make one general remark. After 10 years of application of the succession regulation, we're able to draw on case law by the CJEU, by national courts, as well as on evaluation studies such as the MAPI study carried out by the Notaries of Europe, the collection of cases in the Yearbook of Private International Law, or the European Law Institute webinar series on the application of the regulation in the member states. And I was the Polish reporter back in that project. And these studies highlight challenges and achievements of the regulation. I think, and that's why I'm making this remark, still that a certain self-restraint in recommending changes to the actual text of the regulation seems advisable. Because to my mind, the regulation is a highly successful piece of legislation, a success story that should not be overly disturbed. And Anatol already drew our attention to the difficulties of the transitional provisions. And any change would, again, trigger the need for transitional provisions, which does not exclude, to be sure, changes or modifications where they are appropriate. Articles 21 and 22 contain the basic rules for determining the lex successionis. Details on the scope of the applicable law are laid down in Article 23, on which I will not say anything because that relates to scope and we already dealt with scope. In addition, the regulation contains a number of special conflicts rules, and among these I will focus on Articles 24 and 25 on dispositions of property upon death. In contrast, I will leave out the rule on formal validity because these questions had already been harmonized to a large extent by the Hague Convention on the form of testamentary dispositions. And we mustn't forget that the applicable law may sometimes also be designated by bilateral treaties. We already heard about that. Article 21, paragraph 1, chooses last habitual residence as the main objective connecting factor. Before the succession regulation, many member states had chosen the deceased's nationality at the time of death as the general connecting factor, and for them, the regulation brought an important innovation, really a paradigm shift in applicable law. It is true that the notion of habitual residence is more open, more flexible than nationality, and for that very reason also more difficult to establish than nationality, and probably prone to cause more disputes. However, as lawyers, we are used to look at difficult cases, at hard cases, but we mustn't forget that the large majority of cases is uncontroversial and it's easy to establish habitual residence. Unsurprisingly still, habitual residence still forms one of the clusters of national case law on the succession regulation, such as, for example, the complex cases of son-seeking pensioners, of cross-border commuters, elderly in care facilities, and so on. I'm not going to go into the details of this because this has also been already done in the panel on jurisdiction. Rather, I would like only to offer some comments on how to deal with the uncertainty posed by these complex cases. The text of the regulation does indeed not contain a definition of habitual residence. It does contain some indications in recitals 23 and 24, but that's about it. So some authors advocate a more precise definition of habitual residence in the text of the regulation. I must say that I am skeptical of this recommendation, of this suggestion, because I think in most cases the lack of a definition does not impede the application of the regulation, and in the remaining complex cases, as the regulation itself calls them, I think formulating a manageable catch-all definition for the whole variety of hard cases appears difficult if it is feasible at all. And I think the saying, hard cases make bad law, should warn against any legislative intervention. And I think that also counts for the suggestion of the MAPE study to expand below the level of the black letter text the recitals of the regulation. Because if we look at the recitals of more recent regulations in European private international law, we see a huge inflation of recitals compared to the early Brussels I regulation, for example. And I think there is already a lot in there in the recitals. I think rather the solution of complex cases should be a task for the courts, national courts, and as the notion must be interpreted autonomously also for the CJEU. And there we have the rich case law on habitual residence, for example, in the Brussels II bis regulation, maintenance regulation, Rome III, other regulations were already mentioned in this context. And this case law shows us that the CJEU is really willing to flesh out the notion of habitual residence, which poses, of course, the question how they may be transposed to the succession regulation, and poses the question whether the notion of habitual residence is the same over all regulations. The succession regulation seems to take the position that it has a unique notion of habitual residence, which makes things more complicated. At the same time, all those statements on habitual residence by the CJEU, also in the EE case, the only one in the succession regulation, show that the CJEU's task is rather limited. It is limited to abstract guidelines. We cannot expect the CJEU to really decide in the individual case where the deceased had their last habitual residence. And this decision will remain a task for the national courts. And that fact in itself has a twofold consequence. On the one hand, national courts, I think, should be encouraged, should continue to refer their doubts as to habitual residence in complex cases to the CJEU, even if this comes at the cost of prolonging probate proceedings. There's always the balance, and we talked about this also in the question that was posed to Louis Perrault this morning. Shouldn't there be more requests for preliminary ruling? I think there should. And on the other hand, national case law should be collected and made publicly available in databases. The yearbook of private international law effort is very valuable in this respect, I think. And maybe the EU should also become a player in this and collect cases on the notion of habitual residence. And finally, I think it also calls for closer cooperation by the courts. The pending MMWB case, where a Dutch court and a German court arrived at different conclusions as to habitual residence, shows that there's also a need for courts to cooperate in this context. The general rule in Article 21, paragraph 1 is complemented by an escape clause. I think from a theoretical perspective, if we look at it from the doctrinal heart of the private international lawyer, it is sensible to include an escape clause for exceptional cases. Other private international law instruments on the European level adopt the same technique. In practice, however, I cannot think of a single case that would call for the application of Article 21, paragraph 2. Where habitual residence is to establish a close and stable connection, it is difficult to envision a case which may still be more closely connected with another state. And in particular, the escape clause should not be an invitation for a homeward trend for the court. It has been suggested to resort to the escape clause where the deceased had planned their estate with a view to the law of a particular state that has, for whatever reason, not become the habitual residence, or a related suggestion is to apply the escape clause in cases of a failed choice of law, and then somehow give effect to this failed choice of law. But I think there are reasons why the choice of law failed, and there is no real closest connection to that state in these cases. Another suggestion about which we already talked this morning is to adopt a somewhat leaner notion of habitual residence on the level of jurisdiction and then take additional aspects into account on the level of applicable law. I'm also very skeptical of that because it distorts the concurrence of jurisdiction and applicable law. Let's move on to Article 22, a choice of law, which takes precedence over the general rule contained in Article 21. Party autonomy in succession law has been also an innovation for a number of member states. The provision aims at compensating the lack of stability, of foreseeability, which is inherent in the last habitual residence. The party autonomy granted by Article 22, in fact, enables the testator to opt for nationality instead of habitual residence as the general connecting factor. Especially a testator who intends to move abroad may keep the ties with the succession law of his home country. I think it is sound that there are limitations to this party autonomy, that, for example, but that in the other respect, the party of autonomy offers the testator who has multiple nationalities the possibility to choose any of these nationalities. And I think it is also sound that the principle of unity of succession prohibits a partial choice, for example, a choice that is limited to certain assets or certain assets located in a certain country. Whether such an invalid choice may then be upheld under substantive law is a matter for the law that applies in the absence of a choice of law. It is a frequent suggestion, had also been suggested this morning, to broaden the scope of national laws that may be chosen. And there's one law that is often recommended, and I would agree with this recommendation, and that is to give the testator the possibility to choose the law of the state where he is habitually resident at the time of making the choice. The estate planning of mobile EU citizens who do not necessarily reside in their home country could benefit from this expansion. If you take the example of a person who has lived and worked in Germany, who has his family and his assets in Germany, but who has kept his Austrian nationality, and this person now intends to move to Spain, this person could choose Austrian law, but not German law, which may come as a surprise and also complicate estate planning. The restriction to nationality is being justified by the regulation with the aim of Article 22 to counterbalance the shift from nationality to habitual residence, and also with the protection of the legitimate interest or legitimate expectation of the testator's relatives who are entitled to a reserved share against the manipulation of habitual residence. However, I think the limitation of choice is also an inroad to the free movement of the testator, and I think the difficulties of changing one's habitual residence are also very high, so we shouldn't exaggerate the risk of a testator changing his habitual residence at liberty. On the other hand, I'm skeptical towards an even further extension of the range of available laws, for example, by choosing the lex resite for immovable property or the law applicable to matrimonial property. The first proposition would run counter to unity of succession, and the second proposition seeks to solve a problem, the coordination of matrimonial property and succession law, that would better be tackled elsewhere. Despite the stability provided by a choice of law, it seems that in practice an express choice does not appear very often, at least not as often as one would expect. In Germany, there are cost reasons for that, because including a choice of law into the testament triggers an additional fee for the notary. And there may be other reasons for lack of express choices. However, Article 21, paragraph 2 also allows for an implicit choice that is demonstrated by the terms of such a disposition. The recital 39 and also the case law indicate and confirm that a classic example would be the case where the deceased had referred in his disposition to specific provisions or specific rules of the BGB or of the Austrian ABGB, Code Civil, or to specific institutions of a national law. This reference speaks in favor of an autonomous standard of implicit choice instead of applying a chosen law, for example, to evaluating whether an implicit choice has been made. And in applying this autonomous standard, it seems that national courts are rather generous in assuming an implicit choice when they find sufficient indications in the disposition. In particular, they do not really seem to inquire into the testator's intention to choose the applicable law, which is sometimes labeled as choice consciousness, Rechtsanwendungs- or Rechtswahlbewusstsein. And I think that is also sensible in this context. Article 83, paragraph 4 goes even further by allowing a fictitious choice where a disposition was made before August 2015, which did not contain a choice of law, neither express nor implicit. This is a complex and somewhat hidden provision, and the interpretation of this provision has caused some controversy. The CJU referred to it on 2 occasions in EE and in RKCR, caused some confusion as to whether this is really a fiction or only presumption, but it did not really help us with the conditions of this provision. Any interpretation of the provision will have to strike a balance between 2 competing interests. On the one hand, the provision seeks to protect the testator's reliance in a certain legal situation. The testator who has made his will and wants to rely that his will be given effect. The testator who moves to Spain and thinks he has taken care of everything. And on the other hand, however, the provision can be a powerful tool to oust the applicable law under the general rule, and it can lead to surprising consequences that sometimes even disappoint the expectations of the testator. If we interpret this into this provision in a way that is too generous, we run the risk of overemphasizing this, the second aspect. If it should, I think a more restrictive approach should be taken, which at least calls for some subjective elements, some awareness or even intention that a national law will apply to avoid surprises. However, this will raise the question how to establish and how to prove this subjective element. The provision will remain important for all old wills made before 2015, so it is to be hoped that the CJEU will give some clarification on that, and maybe also testators should consider revising their will and take an express position as to whether they wanted to make a choice or not. In addition to Articles 21 and 22 that designate the lex successionis, Articles 24 and 25 contain special rules on dispositions of property upon death. Admissibility, validity, and in the case of agreements as to succession, also the binding effects, are determined by the lex successionis, are not determined by the lex successionis because we do not know that yet, because the testator may still change his habitual residence. These provisions in their details are quite complex, but generally speaking, they refer to a hypothetical lex successionis, and that is the law that would have applied or that would have been applicable to the succession if the person who made the disposition or concluded the agreement had died on the day on which the disposition was made. Therefore, the special rules aims at legal certainty. It yields a stable, a foreseeable, applicable law and facilitates estate planning. One of the challenges posed by these two provisions is the characterizations of particular institutions of national succession law and their allocation to Articles 24 and 25. I will only focus on the most controversial case, that is the characterization of joint wills that contain binding dispositions. Such a binding effect exists, for example, in German law, much less so, for example, in Austrian law. And therefore, this problem has given rise to litigation, to court decisions in Austria and in Germany. According to the definitions of the regulation, a disposition of property upon death means a will, a joint will, or an agreement as to succession. And as Article 25 only concerns agreements as to succession, and a joint will is a special type of will, it seems that the joint will falls under Article 24. Nevertheless, both the German Federal Court of Justice and the Austrian Supreme Court applied Article 25 to a joint will, even if the joint will is in one single document, only provided it contains a reciprocal disposition that is meant to be binding. And I think this solution seems indeed preferable, as only Article 25 refers to the binding effect of a disposition. It is better suited to accommodate the fact that two persons are involved. In a possible recast of the regulation, one could think about changing this distinction slightly from unilateral and bilateral. So one article for unilateral and the other for bilateral dispositions. Quite surprisingly, the German court assumed an acte clair, but the CJEU will have a chance to express its opinion in the pending Koda case, I think. And in the Mankopf case, it already showed that it is quite willing to also characterize notions of national law. Conflicts rules are embedded in a general part of private international law that sometimes goes beyond the succession regulation and sometimes received a special rule within the regulation. I will not comment on the question whether these rules should be assembled in some sort of Rome Zero regulation because political prospects for such an endeavor appear to be minimal. I will concentrate on the succession regulation, and among the specific provisions, I will focus on renvoi and ordre public. Other topics that are of a more general nature are not addressed by specific provisions. We already talked about characterization. The establishment and application of foreign law, I will leave out, save for one remark. There is difficulties in this respect might also call for more cooperation regarding information on substantive succession laws. I will only say something on incidental questions among these general topics, because in succession matters it is a frequent problem that the question whether a person is a beneficiary under the applicable lex successionis depends on their relationship to the deceased. The position of a surviving spouse depends on the validity of marriage, the position of a child depends on parenthood or an adoption. We call these questions incidental questions, which are outside the scope of the lex successionis. As conflicts rules for these relationships are not yet harmonized within the EU, each member state continues to apply its own private international law. So depending on the connecting factor used, member states may arrive at different results as to the incidental question. The problem now is whether incidental questions should be answered according to the private international law of the forum state or according to the private international law of the law applicable to the main question, in our case, the lex successionis. That's the controversy between lex fori and lex causae approach. The number of incidental questions in succession matters is considerable. Nevertheless, there is, to my mind, hardly any litigation on that, and I think that is because the concurrence of jurisdiction and applicable law really mitigates the problem. However, it does not eliminate it, because in cases of Article 10, for example, the question might come up. The regulation is silent, preparatory documents are inconclusive, so we have to find a solution. The classical approach in private international law would be the lex fori approach, because this approach guarantees that within one legal system, a question will receive the identical answer, irrespective of the context in which it comes up. A person is always married or never married, independent of the context. And Article 1, paragraph 2, the provision on scope that excludes certain matters, seems to confirm this approach. Nevertheless, I think the better arguments in the succession regulation speak in favor of the lex causae approach. And that has to do with the European Certificate of Succession. In many occasions, for example, in the Markov case, the CJEU has relied on the functioning of the ECS as a core argument for interpreting the regulation. However, in order to safeguard the functioning of the ECS, its content must be the same and must be accurate, not only in the issuing state, but in all other member states as well. And that means that incidental questions that determine the circle of beneficiaries have to receive the same answer in all member states. And this can only be guaranteed by the lex causae approach. A few words on renvoi, because the approach chosen by the succession regulation differs from all earlier, but also from all later instruments in European private international law. Whether in the Rome I regulation or in the matrimonial property regulation, renvoi is excluded in both. In contrast, Article 34, paragraph 1a, allows a renvoi to the law of a member state when referring to the law of a third state. I must admit that 10 years ago, I was skeptical about this provision. Not only does it deviate from the prevailing model in European private international law, it also jeopardizes the unity of succession. And if we look at German case law on the provision, this concern is to a certain extent confirmed. Because often third states will provide for a scission of the estate in their private international law and subject movable property and immovable property to different laws. And where the deceased had his last habitual residence in one of these third states, one of the common law countries, Thailand and China were cases in Germany, there is a partial renvoi to German law that only concerns immovable property in Germany. Nevertheless, today, I must say that I think that Article 34, paragraph 1a has proven to be beneficial. It fosters international consistency of decisions, which is in itself an important goal of European private international law. And moreover, where the last habitual residence was in a third state, jurisdiction for, if we stay with the example, German courts is based on Article 10. And in such a case, a renvoi to German law will re-establish the concurrence of jurisdiction and applicable law, which makes things easier. As proceedings often focus on the immovable property located in Germany, the court only has to deal with foreign private international law and not with foreign substantive succession law. And finally, I also like the message underlying Article 31, paragraph 34, paragraph 1a, and that is the fact that all member states are regarded as some sort of single judicial area, and a renvoi to law of any member state is accepted. The last provision I would like to briefly look at is public policy, Article 35. According to a well-known old saying, applying foreign law may amount to a leap into the dark. And that is why all EU regulations on private international law contain a public policy clause as a kind of safety net for this leap. The concurrence of jurisdiction and applicable law reduces the relevance of Article 35 because most of the times a court will not apply a foreign law, but its own law. Where foreign law is applied, however, the clause reserves fundamental values of the forum state against the result that is yielded by the application of foreign law. In order to avoid excessive interference with European harmonization, the application of Article 35 is limited to exceptional circumstances of manifest incompatibility. By far the most problematic issue in this regard is mandatory family protection. As a starting point, we should remember that reserved shares, comparable instruments, are part of the lex successionis, according to Article 23. And in this respect, however, national succession laws vary greatly by providing, for example, a compulsory portion, such as in Germany, forced heirship, such as in France, or a family provision under English law. There's one difference between the systems. While, for example, a compulsory portion in German law does not depend on the need of a family member, the family provision under English law and other common law systems is at the discretion of the court, and it depends on the need of the family member. So the problematic case is the following. We have an English national who chooses English law under Article 22, paragraph 1, disinherits their child and then dies with their last habitual residence in a member state that provides for a reserved share, such as the compulsory portion in Germany or in Austria, which is irrespective of need. Another question will be, if that child has sufficient financial resources and would receive no family provision under applicable English law, is that a violation of public policy? The Commission proposal of 2009 had tackled this question expressly and stated that, I quote, "The application of a rule of the law determined by this regulation may not be considered to be contrary to the public policy of the forum on the sole ground that its clauses regarding the reserved portion of an estate differ from those in force in the forum." The final text of the regulation does not contain a similar clarification, though the question is open. In 2021, the Austrian Supreme Court held that it does, in principle, not violate Austrian public policy if the English lex successionis does not provide for a reserved share for descendants, at least for descendants that are that can maintain themselves. Only the necessary maintenance is truly indefeasible. And already back in 2017, so applying pre-regulation law, the French Court of Cassation had decided that foreign law may not be refused application solely on the ground that it does not recognize reserved shares. However, also the Court of Cassation reserved a safety net and said that foreign law may be disapplied if an heir would otherwise be left in a situation of economic precariousness or need. And this case law was confirmed in 2024 by the Strasbourg Court on Human Rights. Nevertheless, in 2021, the French legislature tried to overturn this situation. In a new article of the Code Civil, Article 913, alinéa 3, it introduced a droit de prélèvement that would grant access to French assets where the applicable law does not provide for a compulsory portion mechanism. Several authors in France, I talked about this with to our French colleague this morning again, and also authors elsewhere call into question whether this provision can actually be reconciled with Article 35. And following multiple complaints, the European Commission has initiated a pre-infringement procedure and suggested certain solutions to the French government. The fate of the provision is therefore uncertain. However, unlike the Austrian and French courts, the German Federal Court of Justice held in 2022 that the application of English succession law, which is chosen in accordance with Article 22, violates German public policy if it results in a child having no right to a compulsory portion, regardless of the child's need. The main argument of the court, of the German court, was the fact that earlier on, the German Constitutional Court had given a constitutional value to the rules on compulsory portion, and now the Federal Court of Justice said that the right to a compulsory portion is being guaranteed by the Constitution independently of the child's need. This decision met with considerable criticism in Germany in legal scholarship, criticism that is also fueled by an ongoing debate in Germany over the question whether to switch from the compulsory portion system to a maintenance system. In any event, it is deplorable that the German court missed the chance to refer this case to the CJEU. Arguably, I think it is preferable to limit Article 35 to a situation in which the child is in need and would indeed be left in an economically precarious state, so the Austrian-French approach, if you will. Although this is only a very brief overview of the problem, which is, I guess, more complex, it should become clear that this issue will also require more attention in the course of a review of the regulation. I will not give a very big conclusion because Anna is already waiting for her comment, and this will also facilitate passing on the microphone. Just only one comment, because at many occasions I said that it is deplorable we lack still case law from the CJEU in Luxembourg. And I think that has also to do with the question who may actually refer questions to Luxembourg. Courts may do, but now we know from the Al-Bausi case that, for example, issuing authorities in ECS proceedings may not. Notaries who deal with successions in many member states may not. So this is also a question whether to broaden the circle of authorities that may involve the Luxembourg court in helping us with the questions that I've raised. Thank you very much.
Thank you very much, Professor Kleinschmidt, for this brilliant presentation. I would, when listening to it, I just thought myself that, well, you justly mentioned the fact that the courts, it is the member states' courts who actually carry the overwhelming burden of interpreting the regulation. And here, well, I think that major obstacle on this way of Europeanizing succession law is actually the fact that member states courts have certain tendency towards pulling themselves the deceased toward them, so they somehow try to wait out the balance of factors within the habitual residence in such a way that actually it appears that the deceased was habitual resident in a country. Well, so now we are passing to the comments by my colleague, Dr. Wysocka-Bar, who certainly will speak about the problem of the interpretation by member states courts. Thank you.
Thank you so much. So I will try now, once we've heard all the different aspects of the succession regulation and law applicable to successions from Professor Kleinschmidt, I've tried to show you what out of these different aspects we've found during our research into the court files that were sent to the Institute. So only the Polish point of view. So first of all, maybe I should explain what are the challenges to this assessment of the application of the EU succession regulation and its 10th birthday. So first of all, rules on publication of decisions, as they are in Poland, it is usually the decision of the presiding judge or of the court director which decisions are published. So there might be smart decisions that never saw light because they are not published in public databases. Some decisions are published in the databases, and then also the information included in those decisions is spread among other courts. Only the decisions of the Supreme Court all have to be published. When it comes to common courts, some are published, some are not, and to be honest, it's not even easy for me to assess what is the proportion between those that are published and those that are not published. Published decisions versus court files. So because I did this research, first checking the published decisions and what comes from the reading of the published decisions, and then I also had the chance of looking into the court files, I see the huge difference. It is really not that easy to understand what happened in the case just reading. Even if the judgment has the reasoning, you understand much more if you read the court files. So for example, sometimes in the court files, I see that the court asks for the information on foreign law to the Ministry of Justice. So at least I know that the foreign law was taken into account. And then when I just read the decision that I found in the public database, sometimes it's not even mentioned if the foreign law was taken into account. Then it's also the question of reasoning. Sometimes the decisions are given, and in many cases, and to be honest, I was quite surprised, the parties don't ask for the court to draft the reasoning. And it is done in majority of the cases that we examine on the application of the party. I was also surprised that parties not often appeal the decisions that they may not like. So then we end up with the decision that lacks reasoning, and therefore we don't know what really happened in the case if we don't go through files, and even if we go through files, still we are not really sure. Also interesting thing is that there is no mention of application of foreign law in a sentence if there is no reasoning, except for one court in Warsaw that simply states that the estate pursuant and then puts the name of the foreign statute. For example, in this case, I use as an example New York Consolidated Laws, Estates, Powers and Trusts Law. The estate was acquired by the applicant based on this provisions. When it comes to scope that we already discussed today, it applies, the regulation applies in EU member states to succession to the estate of deceased person who died starting from the date, 17 August 2015. So out of these matters, only this, as we call it today, magical date, caused troubles to Polish courts. So there are many decisions, but let's say from the beginning of the application of the regulation, that courts either try to apply the succession regulation, or even the second instance courts were forcing the lower instance courts to apply the regulation, even though the deceased died before that date, so the regulation was not applicable. Or other way around, the regulation was already applicable, but even the professional representatives of the parties were forcing the court to apply domestic law that we had in place before the regulation. This usually happens with the rules on jurisdiction. It's easier because those rules are still in the Code of Civil Procedure, whereas the rules on applicable law were deleted from the Private International Law Act. Therefore, it is, I guess, harder to find those rules to indicate to the court that might apply. And regulation applies provided that no bilateral agreement takes precedence. We already know the answer in the OPEC case. Also, this OPEC case then went back to the Polish court. There was something similar to preliminary question asked to the Supreme Court in Poland, who abstained from taking the resolution. And therefore, it was the common court that had to decide on the matter. Because to be honest, in my view, in OPEC case, the Court of Justice left some space, saying like the succession regulation in general is not against your bilateral agreement taking precedence before the regulation, but it is for the domestic court to interpret this bilateral agreement and say, what does it really say? And the court back in Poland decided that no, if it's silent about possibility of choosing applicable law, it means this choice is not admissible. Simple as that. It happened to me to find a case where it was quite obvious that the bilateral agreement should have been applied, but it wasn't. So it's also, we debate a lot about bilateral agreements. Even today we debated a lot about them, but then when it comes to everyday life of the court very easily missed the bilateral agreement that we also have with Belarus that should have been applied. But to be honest, reading the case, it was very simple, no substantial assets, only one applicant. To be honest, as a human being, I was very grateful that the court simply confirmed the inheritance without digging into bilateral agreement and what Belarusian law says. The universal, as we already underlined, is of universal application. So basically, if all those prerequisites are fulfilled, it indicates the it indicates the law applicable to every case. However, what I've seen in many cases, and this is unfortunately this side effect of publishing decisions in the public database, that sometimes the courts also like the copy-paste system. So it appeared not in one decision, not in two, but many decisions I've seen saying that under the current legal framework, meaning after we started to apply the regulation, jurisdictional rules of the Code of Civil Procedure apply to relations between the Republic of Poland and countries outside the European Union, as well as to all successions opened before 17 August 2015. To be honest, I also have seen such thesis in legal literature. So it's also an argument for us that maybe we should also be more clear on when the succession regulation applies, and in general, EU instrument on private international law. How complicated is it? I always present this slide to my students, trying to explain the system of conflict of law rules of the succession regulation. Thank you. Back in the like I always say it that I really need an assistant. Thank you. So before we had like one or two or maybe three rules in the Domestic Private International Law Acts, and now we have plenty of them. So the general lex successionis, that is designated by the connecting factor of habitual residence or the law chosen by the testator, a completely separate rule on the law applicable to admissibility, substantive validity, binding effects, and dissolution of agreements as to succession. Additionally, separate rules that indicate the scope of application of this law. Separate rule when it comes to form of dispositions of property upon death. So in Poland, we are party to Hague Convention, and therefore we should continue to apply Hague Convention to form of wills. And when it comes to agreements as to succession, we can make use of Article 27 of the succession regulation. But I also noticed that courts very easily forgot about the existence of, not all of them, but many, the existence of the Hague Convention. I suspect it can be the reason can be the default of our legislator. So the legislator left in our Code of Civil Procedure those rules on jurisdiction, deleted it from the Private International Law Act. So by deleting the previous rules and inserting a new rule that only informs us that succession regulation applies now, somehow it can give impression that Hague Convention does not apply, because it was clearly indicated in the Private International Law Act before. It's not a big deal, because at the end of the day, Article 27 was mirrored and based on the Hague Convention, so the right law is applied at the end of the day, but the convention is not even mentioned, and it is even a decision of the Supreme Court. Somehow the fresh one from May this year that forgets the Hague Convention. that is a little bit surprising. And then we also have Article 28 that speaks about the law applicable to the form of a declaration on acceptance or waiver. So when it comes to habitual residence, we were faced with exactly the same cases, and as we can see in the reports published in the yearbook. So the discussion was about elderly people who are moved to hospices across borders, also very mobile citizens that move between 3 different countries in a row. Also digital nomads, so people who work for international companies, and suddenly Polish court had to apply Singaporean law because that's where the person had habitual residence. One funny aspect that I've noticed in the Polish cases, which I found quite special, having read about this in the reports in the yearbook, is that when discussing the intention of setting the habitual residence in a given country, in Polish cases, this is an often argument that the person wanted to be buried in Poland. So that indicates the close relation with the country. When it comes to escape clause, no surprise, it was not applied. However, it was discussed, because sometimes escape clause is brought to the attention of the court in the discussion about the jurisdiction. So the court then has to explain escape clause does not operate for the purpose of establishing jurisdiction of Polish courts. Not a lot of cases concerning choice of law. Maybe one case that I've noticed, it was a Swiss pacte successoral that was concluded between the married couple, and the deceased, she had double nationality, Swiss and Polish. The court of first instance said no choice possible, this pacte successoral is not valid. The court of the second instance reversed this decision, but also proceeded in a slightly interesting way, saying the choice of applicable law is valid because it was valid under Swiss law. So it was not the succession regulation that was applied but the foreign private international law rules. As to the Hague Convention, I already speak about this. So when it comes to the waiver of succession, it happens very often in front of Polish courts that the waiver is made, and also the waiver in the name of minors have to be made. We have quite a huge emigration to United States, while these people still inherit assets, immovable property in Poland. Therefore, the declarations of waiver are made in United States, for example. So it is quite nice to see that courts do understand that that declaration can be made in accordance with foreign law. And also here comes into play the application of the 1996 Hague Convention when it comes to any authorization from the court, and this is also governed by the law of habitual residence of the child, so not Polish law. I see that I should now run. When it comes to renvoi, I share fully the views of Professor Kleinschmidt. It is very often applied, and it turns out to be very practical solution, very often coupled with Article 12 and limitation of the procedure. The regulation says that we can limit the proceeding by excluding immovable property, usually from the scope of the proceeding. However, the Polish courts apply it slightly different, saying we limit the procedure to the assets located in Poland. So it's not 100% in line with what the regulation says, but I understood it really in practical terms help the court to simply decide on the immovable property that is left in Poland. So this is applied very often. So a passage that I've seen many times in many cases, according to American case law and legal doctrine, the law of the place where the property is located, lex rei cite, applies. So in this case, so the rules of American conflict of laws are not codified, cover all US states, and are based on precedents, and thanks to this, Polish law can be applied to the immovable property located in Poland. When it comes to public policy clause, again, this is a thing that we debate a lot, but when it comes to practice, I haven't seen public policy being applied or discussed. Only one case, when it was pretty obvious it does not come into play. The only difference would be that in accordance with Polish law, it would be the spouse and the parents of the deceased who would inherit, whereas under foreign law, it would be only the spouse who inherits. But the court said this is absolutely not contrary to our fundamental principles, because also under Polish law, it might happen that parents do not inherit. And this decision popped up only because the court said the same conclusion would be valid under succession regulation, because the case concerned the recognition and enforcement of a US decision. And the last thing, I know I ran out of time, territorial conflicts of laws. So it happens quite often that Polish court has to apply foreign law, like US law, when there is when there are only movables located in Poland, for example, a bank account. It turns out that the deceased had habitual residence in United States or Great Britain or Australia, so the countries that have different succession laws in different provinces or states. And then the court somehow intuitively, they go directly to the law of the habitual residence of the deceased. So they already asked the Ministry of Justice for the information on foreign law. So the deceased was habitual residence in Illinois. Could you please send us the law that applies in Illinois? So somehow the court skipped the first part of Article 36 that says, first we should think what are the internal conflicts of law rules in this state of origin, so in United States, and then if we arrive at the conclusion that there are no such rules, we can treat, we can look into the habitual residence of the deceased. Transitional provisions. So there are many cases where I had impression Article 83, Section 4 should have been at least considered, because how I read the EE judgment, it says, the will at issue at the main proceeding was drawn up before 17 August 2015. The deceased was a Lithuanian national. Therefore, consequently, that law in accordance with which the will was drawn up, without the explanation what does it mean, it was simply drawn up in front of the notary in Lithuania. So if we follow this reasoning, each time there is a testament that was drafted prior to 17 August 2015 in Poland, which also happened very often for example, for those people who live in United States, but they draft the will in front of Polish notary when they come here for vacation. So this should be taken into account. Very often this provision is forgotten. Thank you, and please forgive, I took too much time.
Thank you very much, and we are immediately proceeding to the next panel. Thank you very much to you both for your interventions, and to anyone, if you want to have some coffee, of course, you are invited by the organizers to have one. Thank you.
Good afternoon, everybody. I'm glad to see you today at this conference in this room. Probably you are still here not only because you must wait for the closing remarks of the director of the institute, but also because I'm the chairman of the last panel. Thank you for it. This will be the most important and most interesting panel about the recognition and enforcement of judgment, court settlements, and public instruments, and also about the European Certificate of Succession. We have two speakers, two excellent speakers. First speaker is Ms. Alice Persha, notary in Austria. And the next one is Professor Wołodkiewicz from Warsaw University, but we will talk about him later. Now I will give the floor to Ms. Persha.
Thank you very much. Thank you for this invitation to this fantastic city, to this fantastic institute, and to this fantastic event. I'm very honored to be part of it. My part is to talk about the reinforcement, enforceability, and about, of course, the ECS. And when talking about the succession regulation, you have always to keep in mind the aim of the succession regulation. The aim of the is to make successions with cross-border implications settled in a way that is speedy, smoothly, and efficiently. That is the overall aim, as far as I'm concerned, of the succession regulation. Heirs, legatees, at least legatees having direct part in the estate, as well as executors of wills and administrators, should have the possibility to assert and prove their rights easily, as well as their powers, and this should be done so in another member state. So we always have to keep this in mind. We always have to keep in mind that there are provisions of the succession regulation meant to facilitate the assertion of rights and status, as well as powers of the administrator or the executor in successions with cross-border implications. On the one hand, by facilitating the circulation of existing national certificates as decisions under Chapter 4 or authentic instruments under Chapter 5 of the succession regulation. We already heard today from Martin Magonsky that this is a fiction, that those instruments circulate freely and move freely around Europe, because usually they hit a wall on the other side. And then we also had the European Certificate of Succession created by the succession regulation as a real supranational element. When dealing with the succession regulation, we have also to keep in mind that there is a difference between courts and non-courts. Courts are, of course, courts, but also notaries exercising judicial functions. Only courts and notaries exercising judicial functions are bound by the jurisdiction rules of the succession regulation. That's very important. Decisions they issue are subject to the rules of Chapter 4. On the other hand, notaries not exercising judicial functions are not bound by the jurisdiction rules of the European Succession Regulations. Instrument they issue operate under Article 5 as far as authentic instruments are concerned. Then, of course, we have the European Certificate of Succession that should not take, at least in theory, not take the place of national certificates, but under the principle of subsidiarity, only be another possibility to easily demonstrate or prove the rights as heir or legatees or executor or administrator. And it should not in any case substitute the existing national documents. We have those regulations in Article 62, paragraph 2 of the succession regulation, as well as in recital 69. So where do we stand after 10 years of succession regulation? Well, the ECS, in my view, still struggles in a field of tension between certainties and uncertainties, between questions not addressed or not solved by the succession regulation, and on the other hand, kind of answers given by the CGEU. We have reticence as far as the succession regulation is concerned on the one hand, and the tries and practical creativity on the other hand, trying to bridge the gaps between the necessities of the legal situation in a member state and the aim of the succession regulation. And we have, of course, the wishful thinking that the European Certificate of Succession figures that as part of Passepartout you can use for everything, and which will do everything and help you with everything, and will be the magic wand. You just need to have all your succession problems solved. And on the other hand, the challenging of the ECS by banks, by insurances companies, by other third persons. And then last but not least, we have, of course, the Achilles heel of the succession regulation, that we have the tension between succession law on the one hand and substantive law on the other hand. So whenever you try to use an ECS for the purpose of recording the ownership of the heir in the land register of another EU member state, you will usually just experience this kind of tension. Does it work? Does it not work? Then, of course, we also have decisions and authentic instruments which should be parallel and in no hierarchy to the ECS. But as already said, the free circulation of those instruments is fiction, not reality. One of my favorite examples in this connection is paragraph 35 of the German land register regulation, where there are set out that proof of a succession may only be done by an ECS, so European Certificate of Succession, or a German Erbschein, or the disposition and the official record of the disposition if you have some stipulations on mortis causa set out in a public document. So where are the decisions? Where are the authentic instruments in paragraph 35 of the German land register? We've already heard this morning that there are other implications where German courts will not accept any decision of an Austrian court, like the Einantwortungsbeschluss, or on the one hand is also difficult because they consequently do not accept any national decisions concerning legacies per damnationem, and that's a really, really big issue. So we don't have, I just flipped a slide, I think. Okay, thank you. And as far as the certainties are concerned, we have heard that there are certainties and uncertainties. As far as certainties are concerned, we have certainties concerning the ECS. Well, the ECS presupposes succession with cross-border implication. In only national cases, we have no ECS. And the ECS does only exist within the temporal scope, the territorial scope, and the substantive scope of the succession regulation. So we need succession proceedings on or death on or after the 17th of August 2015. Then territorial scope, we have all EU members except Ireland and Denmark, and former before the Brexit, the UK. Then, of course, we have substantive scope. We already heard that. Article 1 is there, the principal regulation. The ECS may only be issued in the member state where the courts of those member states have jurisdiction under the succession regulation. The ECS is the real supranational element of the succession regulation, an autonomous element titled sui generis. It should be, at least in theory, not be mandatory, but optional. It does not interfere with national certificates of succession, is no enforceable title. It does not create rights, but it certifies rights, is declarative, and has an evidentiary effect. And of course, the ECS should enable heirs, legatees having direct rights in the succession, as well as executors of wills and administrators to easily demonstrate their status and rights in other member states. The ECS is issued for the use in another member state, but once issued, the ECS has the same effects in the other member states where I want to use it, as well as in the state where it has been issued, without any special procedure being required. So there is no need for legalization, there is no need for apostees or things like that. The ECS is also only issued upon request, never ex officio. So even if the succession proceedings have been started ex officio, you cannot ex officio issue an ECS. You need an application for it. And the ECS also creates a presumption of accuracy, even if it's not, as long as someone knows that it's not accurate or is due to gross negligence, ignorant of the fact that the ECS is not accurate concerning the real facts. And the ECS, Achilles heel, is a valid document or should be a valid document for the registration of ownership in the land register in another member state. We have a lot of CGU cases concerning the ECS, almost all the cases. We have Kubicka, we have Mankopf, we have Oberle, we have Briesch, we have Vorarlberger Landeshypothekenbank, we have Registro Centras, we have Embassy, and pending proceedings BNP Paribas Fortis and Mavanak. So it's a lot dealing with the ECS and just adding to the certainties we should have. We have, although, another certainty that the succession regulation does not, in any case, prevent parallel proceedings. Even under the succession regulation, it is possible that you have parallel succession proceedings in more than one member state. On the one hand, because only courts are bound by the jurisdiction rules of the succession regulation. On the other hand, because there are exemptions to the scope of the succession regulation. So you may have things that has to be dealt in another member state because they are not under the scope of the succession regulation. You might have diverging opinions concerning the habitual residence of the deceased at the time of death. There might be also, because we have no register where all the succession proceedings are registered or ECS are registered on an EU level, you might be ignorant of succession proceedings in another member state as well as of assets in another member state. And of course, there are, as we already heard, international conventions binding under Article 75, paragraph 1 of the succession regulation that might need another view. There is no hierarchy between the ECS and national certificates of successions, and there is no priority rule prioritizing the ECS or national documents. And of course, this raises some uncertainties, because what will you do if you have more than one ECS? If you have an ECS in one member state and an ECS in the other, what will you do if you have a decision, final decision with res judicata in one member state and a decision in another member state? What do you do if you have authentic instruments and a decision, or authentic instruments and an ECS that are incompatible? Do we have any hints how to deal with those things? We have hints in Article 40 of the succession regulation, where it is stated for conflicting decisions. Here you have Article 40, grounds of non-recognition. We have kind of a rule for conflicting authentic instruments in Article 59 and Recital 63 of the succession regulation, and some, I think, cryptic wording concerning possible conflicting decisions and authentic instruments in Recital 63. But we do not have any hints or any regulation in the succession regulation dealing with a potential conflict between an ECS and a decision, an ECS and authentic instruments, or among ECSs. I don't know how these questions could be solved. Will there kind of annihilating effect between those conflicting certificates? Will they annihilate each other, but only leaving space for good faith, where you believe in the validity of one instrument, not knowing that there is another? How would you deal with the conflict between an ECS in one member state and a final decision, res judicata, in another member state? We don't know. Those questions, I think, should be addressed also in the revision of the succession regulation. But till then, we have just to try to deal with those things in the practice. So, how will you come to the ECS? The way to the ECS is kind of signed by the succession regulation. You have the issuance only upon application, not ex officio. You have a kind of circle of persons entitled to apply for the ECS that are heirs, legatees, having a direct share at the succession, as well as executors of will and administrators. Person entitled to a legacy per damnationem are not allowed to apply for an ECS. That's kind of a pity, but we have to deal in the practice with it. When you apply for an ECS, you are not obliged to use the form. That's also stated by the CGU as well as the text of the succession regulation. Then the competent authority will do an examination of the application, and then the issuing authority will have to decide whether to issue or to deny the issue of the ECS. Since Abusi, we know that it's also a case of challenges during the proceedings. We'll come to that. We have the contents regulated in Article 68, although the real content of the ECS, according to Annex 5, Form 5 in the implementing regulation, sometimes mixes up the contents of Article 68 and Article 65, I think. But we have the contents in 68 of the succession regulation. The use of the form is mandatory for the issuing authority, so there is no choice whether to use the form or not. So for all of you using the form, as far as I know, the Word format is the common form that is used for the issuance of an ECS. The online format of the European Commission differs from the implementing regulation. So you have online mandatory fields you don't have in the implementing regulation, and vice versa. So it has to be one has to be cautious when dealing with the online form. And then the original always remains with the issuing authority. In Austria, it's the court act, the court file, and the certified copies will do the trick in the world around. We have then, of course, proceedings for rectification, modification, and withdrawal of the ECS, as well as redress procedures and suspension of the effects of the ECS. We have, of course, some court cases, some cases by the CGEU. The first of all I want to mention is Al-Boussi. It was per se not successful because the request of preliminary ruling was considered to be inadmissible, because sometimes even courts are not courts. So you might be a court under Article 3, paragraph 2 of the succession regulation, but that does not mean that you are a court under Article 267 of the TFU. So there might be a difference. And the CGU ruled that issuing an ECS is not exercising judicial functions, because when you issue the ECS, it cannot be issued if the elements to be certified are being challenged. So there was, of course, the question, what kind of challenge? Is this a challenge within the proceedings leading to the ECS? Is this a challenge in another proceedings? What if the challenge is unsubstantiated? What if there is an unfounded challenge? What if there's just a challenge because I want to challenge it and I want to just cheat on someone else, or I'm angry because I don't inherit what I thought I would and therefore try to do a lot of harm to other people, trying to get an ECS. And the CGU, on the one hand, said, well, the request for a preliminary ruling is inadmissible, but on the other hand, told us that any challenge precludes the ECS, no matter if the challenge appears to be unfounded, no matter if the challenge is unsubstantiated, no matter if it's in the proceedings for the issuance of the ECS or elsewhere. So any challenge precludes the ECS. You might be in the lucky situation that you have a game changer in form of a final decision with res judicata. Then you might have something that will do the trick and you might issue the ECS nevertheless. And on the other hand, you are just on the way to the redress proceedings. So there are no other ways. Well, Abusi is quite interesting concerning the effects it will have for other requests for preliminary ruling, and it has led to an international discussion as well as to a discussion in Germany, I think. We have the Vorarlberger Landes- und Hypothekenbank case. It was a colleague that didn't want to bother with the limited time period the certified copy is valid. And he said, well, I just put unlimited validity in it and said unlimited duration. And so I never have to bother to issue the ECS again or to do anything else or to issue another certified copy. It was, of course, the question, what will happen with such an ECS with unlimited duration. The CGU held in the Vorarlberger Landes- und Hypothekenbank case that the ECS will be valid for a period of 6 months from the date of issue, irrespective of the unlimited duration, and produce the effects if it was valid at the time of presentation at the competent authority. Another fact that is quite interesting was also held in this case, that the effects of the ECS produced with respect to all persons who are named in the ECS, even if they did not apply for the ECS. That was also a question what to do if person did not apply for the ECS and was mentioned in the ECS. Was the ECS valid in this respect? And the CGU held it is. Then, of course, the case you all know very well, Registro Centras, German succession proceedings, German law, German sole heir, everything's fine apart from immovable property in Lithuania. In this time, the CGU did something he seldom does. He was not following the opinion of the Advocate General, and has to deal with the question if national law might entitle a registration authority to reject the application for the entry of the ownership in the land register if the ECS as only document presented does not identify the immovable property and does not indicate which assets the heir has inherited. And the CGU said, well, no problem. It was okay to reject that. Well, it does not mean that the ECS as such was not valid or did not have effects, but it was not suitable for an entry in the Lithuanian land register. And kind of answering the Registru Centras case is Mavanak, pending proceedings before the CGEU. Where all those questions would led to the rejection of the application for the land register entry in the Registru Centras case are just put on the plate again, and with the question if Article 68 of the succession regulation, which says that the share for each heir and, if applicable, the list of rights and or assets for any given heir must to be certified in the ECS. So Mavanak will show what we have to include in the ECS. Do we have to take Article 68 seriously and put in the ECS also the indication of immovable property if the heir applies for it? If I want to that the immovable property is mentioned in the ECS, or is there a way to say, well, we never do that, we don't include kinds of property even if there is an application to do so, and we just issue kind of a blank ECS because we have a system of universal succession or for any other reasons. So all those questions are before the CGEU right now. Must the ECS contain the information required under the national law of the sighted state for the recording of the heir as owner in the land register in respect of immovable property forming part of the estate in that member state, when the heir requested that such information be included? And then, is there a difference between a system of universal succession and a system not knowing universal succession? And what if there are other documents presented apart from the ECS showing the immovable property, identifying the immovable property and indicated that the heir mentioned in the ECS has inherited it or that this immovable property is part of the assets? So we will see if this Mavanak will bring the answer to all those questions and to many more, or if the preliminary ruling will be inadmissible. One never knows. But there is a certainty in this relation, because we know when if the ECS does not contain the immovable property and I need the ECS to register my ownership in a EU member state that requires the identification of immovable property in the ECS, that there will be a deadlock to the detriment of beneficiaries. So we have always, I think, to see things from the perspective of the persons concerned. We have on the one hand a scientific view, we have the view of practitioners, and then we have the EU citizen that gets an ECS and tell, well, I have everything I need, I've done everything I can do, and then goes to the land register of another member state, and the land register says, well, no, we don't have all the information we need, we won't register your ownership in the land register. And that should be mended. There should be, there are good practices or tries to just bridge this gap, but perhaps the CGU will answer. We have also been another pending proceedings, BNP Paribas Fortis, that is also very interesting, because on the one hand the question is raised who is entitled to just come in for a preliminary ruling pursuant to Article 267 of the TFEU. I think this first question might be answered by the ruling in the Albosi case. And on the other hand, what are the consequences, also as far as the costs are concerned, if a third party not involved in the process of issuing the ECS, like for example a bank, just challenges the rights and the status of the heir, the rights and the status of someone mentioned in the ECS, and therefore leads to proceedings, to withdrawal perhaps, or in this case just to check of the ECS, and is it possible just to make the third persons challenging the effects of a European certificate of succession? Is it possible for national law just to let them pay for it in one or the other direction? So it's very interesting what will be the outcome of this pending proceedings. Is the bank to which a valid certified copy of the ECS is presented entitled to challenge it? And if it is entitled to challenge it, who will pay the costs for the proceedings? If there are any withdrawal proceedings, or if there are any process started on motion to check the ECS. We'll see. And then, last but not least, we have some other issues. The one we've already heard this morning is the revision and kind of streamlining of the ECS form. As far as I'm concerned, I think the form is kind of tedious, and it's quite really time-consuming to just fill in the form. You have then the divergence of the electronic form of the implementing regulation. So we just try, and there is under the European Judicial Network a working group trying to standardize and to facilitate the ECS, just to reduce it to its content under Article 68 of the succession regulation, and to try to bring benefit for the practitioners. Also perhaps to introduce digital components, because it would be easy to issue the ECS in a digital way and use digital signatures or things like that to identify or better identify the issuing authority. But when we see what we get, we have of course translation issues that might be reduced if we had an online form. On the ENN platform, you can use kind of a passport for companies, and you can issue and you can choose the languages you want to have it. So you can choose, for example, I want to have it in German and in Polish language, and then the system will just make a form in both languages. So such a system would be great for the ECS too. Don't know if we'll get it. Then there is always the question of a register of ECS. I think there won't be any register on European level, but there are still tries to interconnect existing registers, and not all member states have registers. And of course, there is always the attempt to just establish best practices and to work together for the benefit of all of us. Thank you very much.
Thank you, Ms. Persha, for this excellent, interesting presentation about the effects, functions, and issuing of the European Certificate of Succession. Thank you very much. Now we will go to the next topic, recognition and enforcement of judgments, court settlements, and public instruments. And the presentation will give now us probably one of the youngest or the youngest professor of civil procedure law in Poland, my dear colleague, a great specialist in civil, international, and European procedure law, Bartosz. The floor is yours.
Thank you. Speaking last at the conference always poses a challenge. A lot has already been discussed about the achievements and indeed some shortcomings of the EU succession regulation. I will thus try to be brief and rather than revisiting a general subject of recognition and enforcement, focus more specifically on challenges encountered by the Polish courts when confronted with national certificates of succession from another member states. Drawing from this, I will present some recommendation for the possible review of the regulation, as one, in my opinion, is needed. As we know, prior to the adoption of the EU succession regulation, one of the challenges in the cross-border cases was the fact that the decisions delivered in one member state were often non-recognized in others. The regulation aims at solving this by introducing quite complex mechanism that involves three elements: recognition of decisions, acceptance of authentic instruments, and European certificate of succession as an alternative instruments. What does it mean for the regular court? That the court can be confronted with the national certificate of succession from another member state, and at that moment the court needs to decide whether this certificate is a judicial certificate, notarial certificate, or the private affirmation of heirship. But even that qualification could be insufficient for the proper qualification and choosing adequate mechanism for the circulation of legal effects. When presented with a national certificate, a court must autonomously analyze whether the certificate constitutes a decision as defined in the regulation or an authentic instrument. And in many cases, taking into consideration what authority takes part in the issuance of a national certificate is insufficient. As demonstrated also by the preliminary references in cases WB concerning certificates of succession issued by Polish notaries or EE regarding Lithuanian certificates, the classification of a national certificate can be questionable even within its member state of origin. The same can be said also about the German debate about the Erbschein. While the issuing authority qualifies as a court in the meaning adopted by the ACJ in the Oberle, at least a part of the German doctrine classifies the Erbschein as an authentic instrument rather than a decision. If the classification of a national certificate is debated in the member state of origin, the cross-border circulation of such certificate places a very heavy burden on the courts of the member state addressed. Before determining what mechanism is applicable, the court needs to establish the nature of the proceedings in which such certificate was issued, taking into account the foreign law. Also, in such cases, the court needs to, so to speak, resolve the dispute regarding the classification of the foreign certificate that is debatable in the state of origin. Nevertheless, the accurate classification remains a prerequisite for the proper application of the regulation. To illustrate how Polish legal practice deals with this mosaic of national certificates and mechanism for their application, I would like to refer to a specific case that can serve as an example of the difficulties encountered by the Polish courts in applying EU succession regulation. The case began when an heir, having obtained a German certificate of succession, Erbschein, applied to the Polish Land and Mortgage Register Court to be entered as the owner of the deceased real estate. The court refused to recognize the ownership right based on the Erbschein, and so the story begins. Such decision prompted the heir to apply to the Polish court for the issuance of the Polish certificate of succession. Here, a court dismissed the application as inadmissible, citing lack of the jurisdiction under Article 4, which is of course in line with the ACJ Oberle judgment. Seeking another pathway to establish ownership rights, the heir applied for the recognition of the Erbschein as a judicial decision in separate proceedings. Here, application for recognition was opposed by a public prosecutor, who intervened in the proceedings, invoking public policy as the ground for non-recognition. The argument made by the Polish prosecutor was that a foreign decision cannot determine the ownership of the real estate in Poland. To complicate this picture just a little bit, during a recognition proceedings, the applicant subsequently obtained a European certificate of succession. And the public prosecutor also started to argue that the recognition of Erbschein was no longer admissible because the applicant had lost legal interest in the proceedings. So the Polish court was confronted with three questions. Does the German certificate of succession fall under the mechanism for the recognition of decision? Can the Erbschein produce cross-border effects that extended to real estate in Poland in light of the public policy grounds raised by the public prosecutor? And third question, does obtaining a European certificate of succession subsequently results in the loss of the legal standing in the recognition proceedings? The answer provided in that case can be seen as the fortunate outcome, both for the applicant and for our understanding of the EU regime. The court correctly established that the Erbschein is to be recognized as a judicial decision and produces cross-border effects. Furthermore, the court confirmed that the public policy exception does not apply merely because a foreign court ruled on a real estate located in Poland, and what is also quite important in this context, that obtaining European certificate of succession does not prevent recognition of the foreign decision. However, a slightly different approach to the Erbschein has also emerged and can be seen in the practice of Polish court. In these cases, although the Erbschein is recognized as a judicial decision, its effects are limited. A court recognizes an Erbschein, but without recognizing its effect vis-à-vis a real estate located in Poland. However, the reason for this second approach does not lie in the difficulties of qualifying the Erbschein under the regulation itself. It stems rather from an error, the non-application of the regulation at all. In these cases, Polish courts invoked national grounds for non-recognition by resorting to the Code of Civil Procedure. They relied specifically on the doctrine of exclusive jurisdiction of Polish courts over real estate located in Poland. Thus, the second practice, the second approach, stems not from inadequate application of the regulation, but from a failure to apply the regulation at all. For such problems, the most immediate and obvious solution lies within some kind of training activities, but also accessibility of information. I think it would be unreasonable to expect courts to properly apply such complex and nuanced mechanisms as those provided in regulation in the absence of necessary support. We can only bridge the gap between the regulation very ambitious framework and the judicial practice by equipping practitioners with the information they need to apply regulation successfully. Looking at possible solution at a normative level, I would think about introducing a form, an attestation, a certificate, solely for the purpose of the recognition. As currently there is no possibility of obtaining in the member states of origin a standardized certificate that specifically attests to the recognizable effects of a decision for the purpose of its recognition in another member state. While such certificates can be issued in the cases of cross-border enforcement of judgments or the acceptance of authentic instruments, the scope of the information available through such instruments is too narrow to serve the specific needs of the cross-border recognition. The introduction of such form to be used specifically for the purpose of recognition might facilitate better circulation of national certificates of succession. Of course, such form can only be optional, given the principle that decisions are to be recognized ipso iure. On a further level of harmonization, one can also think about changing the structure of the provisions on the recognition and enforcement in the following the example of the Brussels 1bis regulation to make them regulated in separate form. The current structure of the regulation give rise to doubts regarding the extent to which provisions governing enforcement proceedings apply to the recognition of decision. In some cases, simply stating that they apply mutatis mutandis seem insufficient. One practical consequence of this is that foreign authorities in practice can refuse to issue a certificate solely for the purpose to ad hoc recognition in Poland. For this reason, it would be somehow also desire to resolve the question that such form could be issued for the purpose of ad hoc recognition, not only for the cases in which the proceedings concern the declaration of enforceability or recognition as the main issue. What also remains unclear in the context of recognizing a decision is still the very concept and the scope of the recognition itself. This long-standing doctrinal debate has gained new relevance specifically within the context of succession regulation. Turning to the views taken in this debate, some would argue that Article 39 is firmly based on the theory of the extension of effects. According to this view, the foreign decision carries precisely the same effects in the member state's address as it possesses in the state of origin. This aligns with a traditional approach adopted by the Court of Justice under the Brussels regime, tracing back to the explanatory rapport to the Brussels Convention. However, others argue that recognition under the EU succession regulation should be considered alongside equivalence of effect of cumulative theory. According to this view, the effects of decision to be extended to a country cannot exceed those that have the comparable domestic decision. So, at this point, the Article 59 is invoked as the exception, but also as a standard of the having an equivalence of effects theory within the EU succession regulation. At the normative level, the problem, of course, lies in the relationship between the general rule of the recognition of the Article 39 and the specific mechanism for the authentic instruments under Article 59. The dilemma, however, on the more policy level, boils down to the question whether by recognizing a decision from another member state, a domestic legal system, if you allow, is buying a pig in a poke, so blindly accepting the unknown effects of foreign law, or whether some equivalence or cumulative effect, as can be seen under Article 59, is to be assumed. The question has not yet been definitely settled by the case law. While Court of Justice explicitly extends the binding force of the rulings on jurisdiction, irrespective of the effects produced by the decision under the law of the state of origin, significant doubts remain regarding the extension of substantive effect. Leaving this question solely to the jurisprudence does not contribute to the legal predictability. Therefore, a legislative clarification in the recitals at least is needed. Last but not least, I would like to stress a point that has effectively become the ceterum censor of academic writings on the EU succession regulation, that is abolishing the exequatur in the EU succession regulation. Beyond the matters of succession, the days of the exequatur system have largely come to an end. The direct enforcement of judgment given in another member state without the need for a declaration of enforceability is now the prevailing solution under EU law. This principle has been most recently adopted in the family matters and is firmly established in the Brussels 1bis regulation, as well as within the scope of the harmonized conflicts of law rules in maintenance matters. Now, perhaps time has come also to abolish exequatur in the EU succession regulation as well. However, I must add a practical caveat. While such change would harmonize the succession regulation with other EU instruments, it would likely have very limited practical significance. In research project conducted at the Institute of Justice in Warsaw, we analyzed a court practice over the past decade. Surprisingly, courts did not report even a single exequatur proceedings under the regulation. Although it is hard to imagine that this instrument has never been applied in Poland, the data suggests at least that its significance is limited. From a very practical standpoint, the problem of enforcing decision seems to be, at least in Poland, of interest only to academics rather than practitioners. And to conclude, I would say that the primary goal of any future revision of the EU succession regulation should be to improve the mechanism for recognizing and circulating the legal effects of national certificates of succession, rather than just adjusting the regulation to other EU instruments in terms of its enforcement regime. This is also because the latter is a much simpler task. Thank you.
Thank you, Bartosz. It was, as always, excellent. Thank you very much. Do you have any questions to the reporters? Are there any questions? we have time for the discussion. No? Yes, if you want.
On the behalf of the director of the Institute of Justice, Professor Piotr Rylski, he needed urgently leave our conference because of family matters. I would like to thank all of the speakers, all of the participants, all of the moderators for this brilliant conference, for very interesting discussions. And you are always welcome in the Institute of Justice in Warsaw. And once again, I would like to thank you, especially to Professor Bartosz Włodkiewicz for organizing such a beautiful conference. I don't see Dr. Mateusz Grabarczyk here on the left, but he was also a heart of the organizing team. Once again, thank you very much, and you deserve a loud applause. I already thank you, Dr. Grabarczyk, but he already came now. Thank you very much once, and you can also applause him again for the organizing of this conference. As already mentioned, the conference is over, but it's still far away coffee. You are all invited. Feel free. Thank you very much. Have a question?